There's a man, a legal wizard, with a podcast you should hear. Andrew Branca's name, the self-defense pioneer. He knows the law, the ins and outs. He'll take away your fears. His expertise is unmatched. It's crystal clear. The law of self-defense. This book that you must read. 5 elements laid out. He's got all you need. From innocence to eminence, he'll break it down for you. Andrew Branca, he's the voice that rings through. Oh, Andrew Branca, the self-defense guru. He's got the knowledge, the skills, he'll fight for you. Oh, Andrew Branca, the master of the law. When it comes to self-defense, he's the one you should call.
Hey, everybody. Welcome to this episode of the Law of Self-Defense Verdict Watch for Nicolae Miu, charged with first-degree murder, 4 counts of attempted murder, and battery, along with a weapons enhancement in Wisconsin over the Apple River tubing stabbing incident. He, of course, claims self-defense, and we are here to watch the court proceedings. We had closing arguments yesterday. Jury got instructed, went into deliberations. Did have a question yesterday. They wanted to see the video again. The video of the cell phone filming of the event. Yeah, somebody sent me that little ditty last weekend. It's, I don't know how long I'll keep it, but probably for this trial, at least. So they wanted to see the cell phone video again. I suspect that's favorable for the defense. Right now, the news live stream is replaying the state's closing argument, which was not great. Defense argument was pretty good. Could have had a few spots of improvement. Corey Tarafisi did I'd give it a 9 out of 10. Of course, it's easy for me from the sweet seats, not having any of the responsibility to point out things that might have been done differently. I'm sure if Corey were looking at it again, he would be doing the same thing, same critical analysis. He's a good lawyer. That's what good lawyers do. But so we're waiting on a verdict. So what can we do with today? We'll probably watch the closings again. I have an updated jury pool image from the news. It's a little different than I had yesterday because they changed it. Turns out the two alternate jurors are both males, one in their 40s, one in their 60s. We know that there's a 20-year-old, 30-year-old on the jury. Probably the older jurors are more favorable to the defense, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. So at the bottom there, we have the age breakdown for the 12 actual seated jurors, not counting the alternates. 2 in their 20s, 1 in their 30s. May they emotionally identify with the Utes on this river who attacked Nicolae Miu? Whereas the people in their 40s, 50s, 60s, 70s, and 90s, the 90-year-old is still on the jury. Might they be more likely to be empathetic with 52-year-old quadruple bypass patient Nicolae Miu, beset by 13 young, healthy, fit, aggressive youths? And the state made a big deal about the fact that these children, only half of them were children, fewer than half, and those children were 17-year-old high school football players, but that they were unarmed. Folks, I would suggest that they were armed. They were armed with their numbers. They were armed with their fists. They were armed with the river. So they were armed. They were capable of inflicting death or serious bodily injury. The only real question is, did Nicolae Miu reasonably, even if mistakenly, reasonably perceive that that's what they were doing, that they were presenting as an imminent threat of death or serious bodily injury to him? He says he believes they were. That's why he stabbed them. The question is, can the state disprove that narrative beyond any reasonable doubt? Or more accurately, will the jury agree that the state has disproved that self-defense narrative beyond a reasonable doubt? I personally don't think the state's come even close. In fact, I think it's a rather pathetic prosecution. But juries are dangerous and unpredictable creatures. So that's why I don't predict verdicts. But today, I think we'll take another look at the jury instructions, particularly for self-defense, provocation, and retreat. We'll take a look at the cell phone video, the Jawan Cockfield cell phone video again, viewing it in the context of those jury instructions. And then maybe we'll listen to the state's closing argument to see if it makes any sense when it's viewed in the context of the jury instructions and the actual video. I'm going to try to keep the, I won't try, I'll keep the news media feed open here on my desk, but I'll confess it's kind of hard to be doing real-time legal analysis on jury instructions and videos and closings from yesterday, and note if the what's already being displayed as in courtroom scenes from yesterday suddenly switches over to an in courtroom scene from today. So I'll kind of count on all of you in the chat to keep me apprised, particularly in the member chat, the Law of Self-Defense member chat, because I trust you guys. Those of you on YouTube, I don't know, man, and Rumble, you're kind of sketchy. So we are streaming on YouTube, Rumble, Twitter, and of course to our Law of Self-Defense members on their member dashboard. Questions and comments from the members on the member dashboard are always answered for free. If you're on YouTube and you want to pose a question that you'd like me to address or a comment that you'd like me to address, it needs to be a $10 super chat. $10 super chat. Yeah, these high-profile cases, they bring out the wackos into the comments. No question about that. If you are watching on YouTube, it's a subscribe and a thumbs up is always appreciated. And if you'd like all your questions answered for free for a whole month, I mean, then I would suggest being a Law of Self-Defense member. You can be a trial member for 2 weeks for just 99 cents. Get all your questions answered for free. That'll certainly cover this trial, obviously. After that, it's still dirt cheap to be a Law of Self-Defense member, only about 30 cents a day, less than $10 a month, but you at least try it for 99 cents instead of paying YouTube $10 a question. That strikes me as crazy. You can access that trial membership at lawofselfdefense.com/trial, and you'll be immediately emailed the credentials you need to log in as a member and put your questions in the member chat for free and so forth. So lawofselfdefense.com/trial. And with that, let's go ahead and launch the formal start of today's show. Here we go. Darn it, that was the wrong image. That's fine. It went by quick. So today's show is sponsored by none other than Law of Self-Defense itself in the form of our upcoming Law of Self-Defense advanced class. This is the full day class we only teach twice a year. The next date is Saturday, April 20th. It's our full day class taught live by me, streamed to you at your computer, that teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. If Nicolae Miu had taken this class before going tubing on the Apple River, July 30th, 2022, and adhered to what I teach, he would not be in court waiting for the jury to potentially deliver a guilty verdict, which will be effectively, if not absolutely, a life sentence, really, no matter what he's convicted on. Any of the felonies will effectively be a life sentence for 54-year-old Nicolae Miu. You can learn more about this course at lawofselfdefense.com/advanced, but let me give you a quick overview. We teach about defense of yourself, defense of others, your family, your neighbors, your colleagues, your strangers, like an active shooter event. We teach about defense of property, and there's many forms of property in the context of use of force law, and they have different levels of privilege to use deadly force or even non-deadly force in self-defense. There's highly defensible property like your home, temporary homes like hotel rooms or an RV or even a camping tent. There's least defensible property like open, undeveloped land, like personal items, like your pets. Believe it or not, I know you all love your pets. Your pets are least defensible property for use of force purposes. We talk about consciousness of guilt evidence. It's quite a bit of that in this trial. It would have been helpful for Nicolae Miu to have known what that was and avoid it when speaking with the police in the aftermath of this use of force event. And on that note, we spend almost an hour talking about interacting with the police in the aftermath of a use of force event. We believe there's a more professional approach to interacting with the police than simply saying nothing. In fact, in many contexts, we think saying nothing to the police is a bad plan, leaves value on the table. But these interactions are very, very dangerous. They do need to be handled in a professional way. So we teach that in the course of this Law of Self-Defense Advanced class. All that and much more on Saturday, April 20th. If you missed this class, folks, it's October at best before we teach it again. Learn more at lawofselfdefense.com/advanced. And if you can't make the Saturday, April 20th date, I would tell you to sign up anyway, because we'll make the playback of the class available to all the registered students for 2 weeks following the class, so you can watch it at your leisure during that 2-week period. But that only goes out to registered students. And this week, we're still in the early registration period, so you can get 50% off your registration at lawofselfdefense.com/advanced. All right, that's our sponsor. I hope they're happy with my little sponsor read. So, what have we got here? We've got the facts of this case. Nicolae Miu is on the river, floating along with his friends. One of his friends, Ariel, says, "Oh my gosh, I lost my phone," the phone they've been playing music with. He's not too concerned about it. He's got insurance on it. He's not going to take time to go look for it himself. But Nicolae had brought a snorkeling mask and a snorkel with him. And he says, "I'll go look for it." So he starts wandering around the river, going to look for it. And he finds himself in proximity to a group of young men who start taunting him. Now, these men are drunk. These young men are drunk, are high. The one who would ultimately be killed had a blood alcohol level of something like 0.219, so close to triple the legal limit. Others also had high blood alcohol limits. They testified that they were drinking, although, of course, as people do, they tended to lie and minimize how much they were drinking. One of them, when asked, said, "I only had 2 beers." And then when they said, "Well, how do you explain that blood alcohol level?" He said, "Well, I had vodka too." Most of them conceded they'd also been smoking marijuana. So a group of 6 high school football players begin taunting Nicolae Miu, calling him a pedophile, a raper, saying he was looking for little girls. There were no little girls in the river. Nicolae Miu, by the way, at the time, 52-year-old mechanical engineer, never been in trouble with the law a day in his life, never had a speeding ticket. Responsibly employed on the river with his wife and friends from work. Nothing to indicate any kind of child interest, certainly not in that moment. And so these boys are just making this stuff up to taunt him. At one point, the boys are floating in their tubes, Nicolae Miu standing in the river, and one of the boys is filming him. That's the cell phone video we'll see, Jawan Cockfield. And so he's holding up his phone, as you would, right, when you're filming somebody. It's in one of those kind of waterproof type bags that you might use on a river float. Nicolae's friend Ariel's phone had also been in one of those types of bags. So Nicolae says he thought they were holding up Ariel's phone, the phone he was looking for. So he jogs over to the tubes. He says he trips. He falls onto the tubes with his hands. The prosecutor tried to characterize that as some kind of assault. He was trying to touch these boys' legs. In any case, Nicolae Miu then gets up from the tubes. He's dropped his snorkel and mask in the process. He gets up from his tubes and he starts wandering to the other side of the tubes, perhaps, he says, looking for his goggles and snorkel that he dropped. Then he wanders away. He's walking away from the tubes. And I would suggest that interaction has concluded, except that the boys follow Nicolae Miu. Now, he is downstream from them, so they're floating downstream, but it's a big, wide river, 150 feet across. They had room to go around him if they wanted, but they didn't want to. They close proximity with Nicolae Miu. They get closer. They're taunting him again, yelling, shouting. There's no reason happening here. And as they're shouting that this guy's a pedophile and a raper, it attracts the attention of a second group, which we'll call the Carlson group. There were several Carlson family members in that group, as well as some others, friends of theirs. And they start to wander over. Now, Quentin Carlson, the father of that group, says, well, I sent my 2 adult sons over, who were, as I recall, 20 and 24 years old. because I was worried that the old guy surrounded by these youths was going to get the brakes beat off him. So Quentin Carlson sends his 2 boys over because he's afraid that Nicolae Miu's going to take a beat down in the river. That was his perception of events. But before the 2 boys even get over there, 2 women come over from the Carlson group. Madison Cohn and Riley, with a unusual spelling, Riley Mattison. They come over, they close proximity on Nicolae Miu, and he walks towards them because he sees what appears to be adults, and he thinks, maybe I can, these adults will help me reason with these teenagers. I'm just looking for my goggles and snorkel and phone, Ariel's phone. But these adults are not there to reason. They're all drunk too. So Madison Cohen's got a beer in one hand, a vape in the other. She's got her cell phone tucked in her top of her bathing suit. Riley Cohen's also been drinking. They get in Nicolae Miu's face by really every witness's testimony pretty much said, yeah, they were in his face. They're shouting, they're cursing at him, they're pointing at him to go down the river away from everybody else, away from his own group, by the way. They don't know Nicolae Miu's with another group, but of course, Nicolae knows that. His group is upstream. They're pointing him downstream. Nicolae Miu, at this point, he's trying to explain to these girls what's going on, and there's so much screaming and yelling, and the teenage high school players are laughing and chortling and shouting. It's a pretty chaotic scene. Nicolae Miu starts getting nervous, and he takes a folding knife out of his pocket and opens it up, and he just holds it by his side, pretty much, or in front of himself at his waist. Madison Cohn and Riley are not only in front of him, screaming in his face, pointing down the river. Now they start touching it. Nicolae Miu would say pushing, shoving, grabbing at him. He still doesn't do anything at that point, except he raises his left arm to, he says, fend off Madison Cohn. That would later be characterized by the state as a punch, a hook to Madison Cohen's face. Nicolae Miu weighs 250 pounds. Madison Cohen probably weighs 150, judging by the photo. The punch is not caught on this video. There's no evidence that Madison Cohen went into the water. She didn't lose her beer. She didn't lose her vape. She didn't lose her cell phone out of the top of her bathing suit. She's not wet afterwards. She has no injury, no visible injury to her face. There's no photographic objective evidence. She would later claim that she had swelling, but there's no evidence of it. She was interviewed by police multiple times right after the event and afterwards. The police didn't note any injury to her. She claims that's a punch. So that's the grounds for a battery charge against Nicolae Miu. The state claims that as a result of that battery, one of the young men from the Carlson group punches Nicolae Miu in the face. That certainly is caught on film. We see that punch. Nicolae Miu is punched off his feet backwards into the river, falls into the river, says he hits his head on river rocks. It's only about 15 inches deep there. Falls on his back. And the aggression doesn't stop there. So arguably, if that's all that was done, that would be the end of the fight. You might say, well, they perceived, mistakenly or not, that Nicolae Miu had punched Madison Cohen, and so they punched him in defense of her. That would be that would be a lawful use of non-deadly force in defense against what they perceived, accurately or not, as Nicolae Miu's use of non-deadly force against Madison Cohen, proportional defensive response in defense of others, fine. But it doesn't stop there. Because Nicolae Miu is hit again while he's on his back in the river. And by the way, 15 inches is enough. When you fall back, the water comes over the top of your face, right? Nicolae Miu would say he felt like he was drowning. They hit him again while he's on his back. He manages to roll over. He gets on his hands and knees, and someone pushes on his back into the water. And then he gets hit again when he's down in that position. So at this point, he gets up, and more people are coming at him, and that's when he starts to bring the knife to bear. He starts making short jabs at people, but the injuries end up being horrific. One of the people he jabs and remember, he's holding the knife basically at waist level and bringing it in an upward motion in what he claims is self-defense. One of the people he does this to, the knife goes into the belly, and that person shoves at the same time, is lunging at Nicolae Miu. And as Nicolae Miu's falling back, the knife comes up and disembowels that person. So it's sliced from his belly up to his chest. A lot of these injuries with this little folding knife were really horrific. But all of them occurred while someone was either obviously on film attacking Nicolae Miu or could reasonably be perceived as attacking him in the moment. Nicolae Miu didn't stab anybody who did not put hands on Nicolae Miu. He's not wandering around stabbing people randomly in the river. Everyone he stabs is someone who committed at least a battery on him. And of course, he's not by himself. He's surrounded by this entire group. Now, not every person in the group physically attacked Nicolae Miu, but no one who didn't was stabbed. And the perception looked something like, see if I still have the figure up. I'd like to think I wouldn't have closed it. Oh, here it is. Like this, the blue dot is Nicolae Miu. G1 is the 6 high school teenagers, which the state and the state witnesses continuously characterized as children, like they were 12 years old. These are 17-year-old, very fit high school football players. A couple of them are now competitively playing football and or wrestling at the college level. Those are the 6. Let's see. 1, 2, 3. There's only 5 here. I wonder where the 6th one is. I'm not sure. But there were 6 of those teenagers. They come from the G1 group, the high school group. And then the G2 group is the Carlson group. And here we have Madison Cohen directly in front of the blue circle and triangle. The triangle represents the direction in which Nicolae Miu was facing. He's facing Madison Cohen. Riley Madison is to his left. And Dante Carlson, who would throw the punch and then follow-up blows to Nicolae Miu when he's down in the water, is right there as well. The JC here is Jawan Cockfield. He's the one recording. From his camera angle, it looks like Nicolae Miu is only facing 2 girls. And the state continuously tries to create that impression in the jury's minds. Look, all we see is the 2 girls, ignoring all these other people also facing off towards the defendant, many of whom were involved in attacks on the defendant. Let's see. It doesn't show. Oh, here, IS here on the left. Right below that G1 is Isaac Shuman. He would be the one fatality. One of the last, if not the last, stabs in this event. He would end up stabbed in the chest, and the knife would pierce his heart, and he would be essentially killed instantly. 4 other people were stabbed non-fatally. They survived, including the gentleman who was disemboweled. His intestines were out in the river. Riley Madison was stabbed. I'll pull up a graphic with those people who were stabbed. So we end up with 1 first-degree murder charge, 4 attempted murder charges in the first degree, all of those also in the second degree. And then at the last day, before the jury was instructed, the state requested and received, in addition to the murder charges, also reckless homicide charges in the first and second degree, or reckless homicide in the case of Isaac Shuman, reckless endangerment in the case of the other 4. And of course, the battery charge on for the purported punch against Madison Cohen, and a weapons enhancement as well. So let me pull up those. I have I have a little PowerPoint. A PowerPoint. Everybody loves PowerPoints, right? I have a little PowerPoint of the charges and the sentences. Let's see. Well, what happened to that? Maybe it's in my general folder. Yep, here it is. All right, so count 1, Isaac Shuman, the fatality. Charge of first-degree homicide. That's a Class A felony. The minimum sentence, if Nicolae Miu is convicted of this, is life in prison. There is no option. Second-degree murder, if the jury doesn't buy first-degree murder, Class B felony, that's good for up to 60 years. And by the way, if he's convicted, I fully expect this judge to hit him with the maximum of all these charges. Once you're convicted, you're just convicted. The jury's decided you did these things, and it wasn't self-defense. And if it wasn't self-defense, these were horrific stabbings. Then we have counts 2, 3, 4, and 5. These are for Dante Carlson, Tony Carlson, A.J. Martin, who was disemboweled, and Riley Madison. first degree reckless. Sorry, this should read reckless endangerment. I gotta fix that. That's not right. Well, I'm glad I noticed that. I'll have to fix that, folks. They weren't killed, so there's no reckless homicide here. My mistake. Count 6 is the battery against Madison Cone. Class A misdemeanor, good for up to 9 months. But of course, if he's convicted of that, he'll be convicted of everything else as well. Because if you believe he committed battery on him, then he's almost certainly the unlawful initial aggressor here and loses self-defense. And because he used a knife, Wisconsin has a weapons penalty enhancement. For any of the felonies, it would tack on an additional 5 years because he used the dangerous weapon, the knife. For the misdemeanor battery, it would add on 6 months. Although he didn't commit the battery with the knife. That was supposedly just a punch. So I guess the 6-month enhancement would not apply there. All right, let's take a look at the jury instructions for self-defense, the self-defense related ones. And I have to blow my nose. Hold on one second, folks. I've been on mute. Well, the good news is you've mostly missed me updating the PowerPoint slides. So let me start again. Isaac Shuman, count one. Isaac Shuman was a fatality. First degree homicide is a Class A felony, minimum sentence of life imprisonment. He's also charged as a lesser included second degree intentional homicide, Class B felony, good for up to 60 years. There is a weapons enhancement charge here for the use of the knife in the killing. That adds 5 years to either of these, which doesn't really matter for the life imprisonment, but would make the up to 60 years 65 years. Now, I would expect, by the way, this judge, if this defendant is found guilty, to sentence him to the maximum on all of these, because if Nicolae Miu is found guilty, that means the jury concluded it was not self-defense. And if these stabbings were not self-defense, it's just a group of horrific stabbings. That's all it is. So I would expect him to get the maximum of any of these if he's not acquitted on the grounds of self-defense. For counts 2, 3, 4, 5, these are the people who were stabbed but did not die, remarkably including A.J. Martin, who was disemboweled on the river. First degree reckless endangerment, second degree reckless endangerment. First degree is a Class F felony, good for 12 plus 0.5 years maximum, plus 5 for the knife. If it's only second degree, it's a Class G felony, good for up to 10 years, plus 5 for the knife. Now, normally, by the way, all the sentences would be served concurrently. And if he's convicted for the killing of Isaac Shuman and gets a life sentence, that hardly matters. But maybe the jury decides Isaac Shuman was self-defense, but some of the others weren't. So he gets convicted of some of these. So 10 years, 12.5, plus 5 for the knife. The judge has the discretion under Wisconsin law to sentence him consecutively, not concurrently. So not in parallel, but stacking each sentence on top of the other. What are the factors that judges might use to break the norm of concurrent sentencing and go to consecutive sentencing? Well, one is that the victims were vulnerable persons. Here we have technically children, 17-year-olds, right, were some of the victims. Another is that there were multiple victims involved. And here there are multiple victims involved. So it wouldn't surprise me if sentencing were to go that way, that the judge would sentence him consecutively, not concurrently. Remember, if this was not self-defense, this is just a horrific group of stabbings. Then the purported battery and Madison Cone, the punch in the river, that's a Class A misdemeanor up to 9 months. And the weapon sentencing enhancement adds 5 years to any of the felonies because the knife was used in all of the felonies. Yeah, I have a long list, by the way, of I occasionally keep track of killings by children. Let me pull up. I'm not going to display it on the screen, but just a few from my notes, because this comes up. Oh, he was just a child. Uh-oh, is something happening here?
Arguments from St. Croix County District Attorney Carl Anderson. On the other side of your screen is a live look at.
Doesn't look like anything's happening.
That shot up for you. That just is letting you know nothing is happening inside the courtroom. So much, though, happening in a nearby jury room. The jury now deliberating.
Okay, so nothing happening yet. That was just their playback of the state's closing had wrapped up. So just some, I'm just going to read the headlines. A teen 13 years old, charged with capital murder in deadly San Antonio carjacking. That was just this week. Dallas girl, 14, charged with murder after shooting and killing 11-year-old boy while aiming for another girl she was fighting in a parking lot. DC police arrest a 12-year-old for assaulting a Good Samaritan and carjacking. 9-year-old armed robber in Washington, D.C. A 9-year-old armed robber. 12 and 13-year-olds suspected of committing an armed carjacking, shooting at police while fleeing from them in a high-speed chase in Seattle. 13-year-old charged with first-degree murder in a Subway shooting. This is the RTD right here in Denver. 13-year-old charged with first-degree murder. 14 and 15-year-olds charged with attempted murder. So just because someone is 13, 14, 15, 16, 17 years old doesn't mean they can't kill you more frequently each other. They do it by the score in cities like Chicago and Detroit every weekend. So, and of course, these were not 13 and 14-year-olds. These were 17-year-olds. No one looking at the images of these young men, these young high school football players, would literally think of them as children, like going trick-or-treating on Halloween. These were young men old enough to enlist in the military and be trained by our government to kill our enemies in numbers. All right, so let's see. There had been a little graphic here. Whoops, there it was. Hold on. I'm going to pull this up to share. The non-fatal stabbing victims. And I'm going to play the Jawan Cockfield cell phone video in just a moment, and we'll get to see what Isaac Shuman looked like as well. Let's see, open file. So these are the non-fatal stabbing victims. Riley Madison, of course, is a woman, but she wasn't alone. Obviously, she was part of this larger group, this ongoing attack on Nicolae Miu. And then we have Tony Carlson, Dante Carlson. They were adults. One of them is 24, the other is 20, or was at the time, a couple of years ago when this happened. AJ Martin was the one who was disemboweled. He's lunging at the defendant's neck when he's stabbed, pushing Nicolae Miu back into the water on his back again. So none of these are anything you would call children. The attack occurred just not even 2 years ago, July 30th, 2022. Isaac Shuman was one of the 6 17-year-olds, high school football players there. We'll see a picture of him when we look at the cell phone video. And he was quite aggressive towards the defendant. He was one of the leaders who closed proximity on the defendant after the inner tube incident. So I think I'll kind of go through the inner tube incident. I can't really decide how I want to do this. Let me see. I have a slowed down version of it. But let me pull up the full speed version. It's about 3.5 minutes long, the video. Maybe I'll try to go like frame by frame through it. Or should I do that in the slow version? Let me do it in the slow version. It's easier to capture the frames that way. And then I'll play it at normal speed with the audio. So first I'll do it without the audio, because the audio, it's so chaotic, it can be very distracting. I don't think I'm still muted, but some of you may be a little bit behind. I was muted before. Sorry about that. It happens. Any of you who watch my content know it happens. I guess I should just blow my nose and let everybody hear it instead of trying to use the mute button back and forth. I've done a poll, of course, but I'll do another poll. Here we go. I'll do a new poll for this morning. Predicting the verdict. Actually, let me rephrase that. Based on law and evidence, should defendant be found guilty or not guilty? Maybe later I'll do a poll on what you think the jury might actually do, which that's not the same question, right? Because juries are dangerous and unpredictable creatures. Based on law and evidence, should the defendant be found guilty or not guilty? This is on YouTube. I can't do polls on the member dashboard. I'm sorry about that. Yeah. So based on the law and evidence, is the poll up? It should be up. It's up. Ooh, wow. The early results are are pretty pretty decisive. I'll wait until we get at least 1,000 votes, which should only take a minute, really. And again, if you're on YouTube, if you're doing the poll, you get the benefit of being able to participate in the poll. Why not hit the subscribe button and the like button? That would be a nice thing to do, as long as you're there. It could, of course, also be a mistrial, but a mistrial is not really a legal conclusion on the facts and evidence, right? Nobody wants a mistrial. Certainly the court doesn't want a mistrial. All right, so back with this little video clip. Let's see how I can go through this and catch so let's watch it. You know what? Before we do that, let's actually take a look at whoops. It started playing. I didn't want to do that. Let's look at the actual law, and then we'll see how the facts fit the law. So, Wisconsin jury instruction criminal 805. This is the state's deadly force self-defense instruction, which is what we're talking about here. Maybe I should pull up the non-deadly force instruction as well, because of Madison Cone. Let's see. I hadn't done that yesterday, so that'll be new. Criminal jury instructions. Go to that one. All right. So with respect to Nicolae Miu, either pushing Madison Cone away or punching her, depending on whose version of events you prefer to believe, there is no objective evidence of any punching of Madison Cone. There was witness testimony by the state's witnesses, so of course all self-interested in claiming there was a punch. Jury instruction 800. Self-defense, force less than likely to cause death or great bodily harm. And that certainly would characterize the punch to Madison Cone. I mean, there's no evidence she had any injury at all. No objective evidence. Nothing that the police who talked to her that day noted or afterwards. No photos, no medical records, nothing. So the jury instruction for non-deadly force self-defense reads, self-defense is an issue in the case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if, actually, let's structure this a little better. The 5 elements of self-defense, which I talk about all the time. So, can I get those on camera? Innocence, imminence, proportionality, avoidance, and reasonableness. Those are the building blocks for any claim of self-defense in any American jurisdiction, any state, any territory, Washington, D.C. It's all a common framework for the law. Now, every jurisdiction has their own statutes, court decisions, jury instructions, but these underlying 5 principles are the same, and that just reflects how old and well-established a body of law self-defense law is. I mean, we find these same elements dating all the way back to the ancient Greeks and Romans, probably before then. Arguably, self-defense is the most fundamental natural law that exists, right? Even animals in the wild defend themselves against attack. Now, not all these 5 elements are always required. Sometimes often, one or more elements is legally waived, is not required. We'll talk about that in just a moment. But there's only up to 5. So there's not 500 elements of a claim of self-defense. There's not 50 elements of a claim of self-defense. There's only 5: innocence, imminence, proportionality, avoidance, and reasonableness. Innocence essentially means that you can't have been the initial aggressor or provoker in the confrontation. If you are, you lose the element of innocence, you lose self-defense. Whichever one of these 5 elements are required, again, some of them might be legally waived, but whichever ones are required. They're cumulative. So you can think of these not only as the building blocks of any claim of self-defense, but as the target of attack for the prosecution when they need to overcome a claim of self-defense. So if you claim self-defense and there's more than 0 evidence to support that claim, the burden shifts to the state to disprove self-defense beyond a reasonable doubt. But they don't have to disprove self-defense in its entirety. They have to disprove any one of the required elements because they are cumulative. If all 5 elements are required in your circumstances and 4 of them are 150% in your favor, but one of them can be disproven beyond a reasonable doubt by the prosecution, you have no claim of self-defense because you're missing a required element. You're simply guilty of the underlying criminal offense. And the prosecution knows this, of course. He knows he doesn't have to defeat everything. He has to defeat one of the required elements. And one of those could be innocence. So if you were the initial aggressor, physical aggressor, meaning the first person to threaten or use unlawful force, or you were the provoker, you provoked the confrontation unlawfully, you lose the element of innocence. If you've lost the required element of innocence, you lose self-defense. And innocence is always required. It's never legally waived. Now, the good news is that it's possible to lose innocence and then regain innocence. We'll see this in the Wisconsin jury instruction on provocation. So you might have been the initial aggressor. You shoved that person. You're the first person to threaten or use force. You've lost the element of innocence. You're now guilty of a simple battery. That was not self-defense. But if you suddenly go, oh my God, what am I doing? I lost my mind for a second, but I've regained my senses. Sorry, buddy, I don't want to fight. Well, you've effectively withdrawn from the confrontation, communicated your withdrawal, and now you're backing off from that confrontation. You're still on the hook for that simple battery. You're still on the hook for the shove. That doesn't go away. But now for the fight to continue, if you're backing away, what has to happen? That other party has to come to you and be the initial aggressor in a confrontation with you. That's a second fight. The first fight ended when you withdrew. Now a second fight has begun in which they're the initial aggressor in the second fight, and you do have the element of innocence for that second fight. Not for your shove. Your initial shove is still on you. But for the second fight, you've regained innocence. You've regained self-defense, or at least assuming you have the other elements as well. Another way you can regain innocence is if you shove somebody unlawfully, so you're the initial non-deadly force aggressor, they would be privileged to use non-deadly force in self-defense. Maybe they shove you back to create space. Maybe they use pepper spray on you. Maybe they, use some non-deadly degree of force. That's just lawful self-defense on their part. But what if they don't limit themselves to a non-deadly force response to your non-deadly force threat? What if they escalate from non-deadly force to deadly force? Well, that would be a disproportional response. We'll talk about proportionality in a moment. It's a distinct one of the 5 elements of self-defense. But if you provoked a non-deadly force fight, like a shove or a typical punch, and they respond by escalating to a knife or a gun, they've essentially started a second fight. They are now the initial aggressor in a deadly force fight that they began. And you've regained the privilege of self-defense to defend yourself against their unlawful escalation to deadly force. All of that might come into play on the facts of this case. So that's innocence. How you lose innocence, how you can regain innocence by withdrawal and communication, or if the other party unlawfully escalates from non-deadly force to deadly force. Now, obviously, if you were a deadly force initial aggressor, there is no escalation possible by the other side. You're already in the deadly force bucket at the deadly force level, and they're privileged to respond with deadly force in self-defense. So this escalation question only arises if your initial provocation was limited to non-deadly force only. So that's the element of innocence, the first element of the 5 of self-defense. The next is imminence. Imminence means that what you're defending yourself against has to be an attack that's either actually occurring, you're taking blows, or it's immediately about to occur. You do not have to wait to be injured before you can defend yourself. You don't need to have suffered a scratch before you can use even deadly force in self-defense. So if someone says, I'm going to shoot you and kill you, and they reach for a gun in their waistband, you don't have to wait to get shot before you can defend yourself against their unlawful threat of deadly force. You can pull your own gun and shoot them first. And if you shoot them first and you neutralize them, and they never have an opportunity to shoot you, you've not suffered a scratch. That doesn't make your use of deadly force in self-defense unlawful. There's no requirement that you be injured first. You're allowed to defend yourself against the attack that's imminently about to happen. What you can't do is defend yourself against an attack that's in the past and over. And you can't use force to defend yourself against a future speculative threat that may never happen. Somebody says, I'm going to go home and get a gun and come back here and use it on you. Well, when they come back with the gun, they may be an imminent threat. But when they're making that threat of future harm, they're not in that moment an imminent threat. And imminence can be thought of like a window that opens and closes. So you're in some kind of confrontation, maybe it's just verbal, then it escalates to a use of force against which now you're facing an imminent threat of a use of force, unlawful force against you. You can defend yourself. The window of imminence is open. There's an imminent threat. And then the person walks away and the window of imminence has closed, right? Because they've withdrawn and communicated. They're no longer a threat to you. The moment the window of imminence closes, your privilege to use force in self-defense also closes. Your privilege to use force in self-defense only exists so long as you are facing an imminent threat, actually occurring or immediately about to occur. Proportionality has to do with the intensity of the force involved. And it's proportional because we're talking about two forces. The amount of force you can use is inherently a function of the amount of force you're threatened with, the amount of force the other party is threatening you with, the aggressor. If they're only threatening you with non-deadly force, force not likely to cause death or serious bodily injury, you can only defend yourself with non-deadly force. There are some exceptions in the context of highly defensible property like your home, but I'm going to skip over that because in this trial, we're not talking about that. This just happened in a public place on the river. So only threatened with non-deadly force, you can only use non-deadly force to defend yourself. You can't use deadly force to defend yourself. Force likely to cause death or serious bodily injury unless you're facing a threat of death or serious bodily injury. Now, once you're in the deadly force bucket, once you are facing a threat of death or serious bodily injury, the law doesn't care much about the nature of your deadly defensive force. It doesn't really care if you're using a gun or a knife or you're beating that person to death or you're choking them to death or you're throwing them off a building or you're dropping a piano on them from a great height. The law cares a lot whether or not you're privileged to use deadly force in the first place. But once you are, it doesn't really care what the nature of your deadly defensive force is. And it's not necessary that the person or people you're defending yourself against have a weapon. The legal question is, are they reasonably presenting as an imminent threat of that can readily cause death or serious bodily injury? That could be an unarmed person who is much larger or stronger than you. It could be a disparity of numbers situation where you're the only defender and there's multiple attackers. It could be they're using the environment as a weapon. Like here, the river to drown someone would be inflicting death or serious bodily injury, but they're not using a gun or a knife to do it. They're just using their hands to do it. In a real sense, we're all armed, right? We're armed with our hands and with our feet and with the environment, rocks, water, sidewalks, cars, whatever. So the fundamental question is not the details of how the force is being inflicted, but however it's being inflicted. Is it reasonably perceived by the defender as being able to readily cause death or serious bodily injury? That's proportionality. Avoidance. Avoidance is the most commonly waived of these elements. I mentioned not all five are always required. Avoidance is the one that's waived most frequently. There are only 11 states that would qualify as duty to retreat states, where you always have a legal duty to retreat if safely possible, before you're legally privileged to use deadly force in self-defense. That's the element of avoidance. Do you have that legal duty to retreat before you can use deadly force in self-defense? But that's a minority of states, only 11, and the number keeps dropping. My entire legal career, a bunch of states have shifted from duty to retreat to doing away with that legal duty, effectively becoming stand your ground states. But there are 11 that are still duty to retreat states. In those states, if you have a safe avenue of retreat and you don't take advantage of it and you use deadly force in self-defense, you violated the required element of avoidance. You're missing a required element of self-defense in those 11 jurisdictions, and you lose self-defense entirely because avoidance is a required element there. In 39 states, there is no legal duty to retreat. Now, I call those stand your ground states. You have a legal privilege to stand your ground. There is no legal duty to retreat. Wisconsin is among those 39 states. But most of those stand your ground states are what I call soft stand your ground states. Stand your ground comes in two flavors, hard and soft. Let me talk about the hard stand your ground states first. So of the 39 stand your ground states, there are 7 that are what I call hard stand your ground states. In those states, the jury is told they are not allowed to even consider the possibility of retreat in evaluating the reasonableness of your use of force in self-defense. In those states, and by the way, they're Colorado, Louisiana, Mississippi, Ohio, Texas, Utah, and Washington. In those states, the jury is not allowed to consider the possibility of retreat. Avoidance as an element is taken off the table completely in an otherwise lawful case of self-defense. And because the jury is not allowed to consider that as a factor, the prosecution is not allowed to argue to it, because you're only allowed to make legal arguments in court that would be relevant to a jury coming to a verdict. But that's only 8 out of 39 stand your ground states. The other 31 stand your ground states are what I call soft stand your ground states. And in those states, you don't have a legal duty to retreat. But if the jury believes you could have safely retreated, they're allowed to consider that in evaluating the reasonableness of your use of force. Essentially, the prosecutor can tell the jury, ladies and gentlemen of the jury, this defendant didn't have a legal duty to retreat. We're a proud stand your ground state. But if you believe safe retreat was possible and a reasonable person would have safely retreated, then you can conclude that this defendant's use of force was not reasonable. And reasonableness is the 5th element of self-defense. If you lose reasonableness, you lose self-defense. So it's kind of a flanking attack on your failure to retreat through the element of reasonableness instead of through the element of avoidance. And Wisconsin is a soft stand your ground state. We'll look at that jury instruction in just a moment. So we've covered innocence, imminence, proportionality, avoidance, and reasonableness. Now we'll cover reasonableness. There's 2 facets to reasonableness, subjective and objective. Subjective is it's necessary that the defendant had a genuine good faith belief in the need to act in self-defense. And usually, we don't have mind reading machines, so we have to rely on the testimony and conduct of the defendant. A lot of bad guy cases of self-defense get blown up on this subjective reasonableness requirement because there'll be evidence, for example, that the defendant ran at or went to find the victim. Well, normal, reasonable people don't close proximity on someone they think is trying to kill them, right? They create distance. So that would be inconsistent with a subjective, genuine, good faith belief that that person was trying to kill you. Or they could testify, like Nicolae Miu did in this case, and say, I thought I was going to die. I thought they were going to kill me, cause me death or serious bodily injury. So usually the subjective part of reasonableness is not that hard to satisfy. But however genuine and good faith belief in the need to act in self-defense you have, if that belief is speculative or irrational, it's not sufficient, because there's a second half to reasonableness. That subjective belief also has to be objectively reasonable, meaning a hypothetical, reasonable, and prudent person would have shared that belief. In other words, it wasn't speculative or irrational. It was objectively reasonable. You need both. You need the subjective belief and the objective reasonableness to satisfy the requirements for the element of reasonableness. And if you don't have both, you don't have self-defense. Now, if the only defect in your claim of self-defense is objective reasonableness, you genuinely thought you needed to act in self-defense, but your belief was irrational, you might qualify. You won't qualify for self-defense, the perfect defense of self-defense. We call it a perfect defense because if the jury believes it, you have zero criminal liability. It's an acquittal. There's also something called imperfect self-defense, not perfect self-defense, where the only defect in the claim of self-defense is that it was not objectively reasonable. You can't get an acquittal on that basis, but what can happen is what would have been a murder conviction gets mitigated down to a manslaughter conviction. So those are the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Now let's take a look at Wisconsin self-defense law and see if we can identify those 5 elements. They don't call it those things, and often they don't bullet point it into 5 distinct elements like I do. It's very common for courts to, frankly, in my opinion, for the law, I should say, to sloppily conflate 2 elements into 1 bullet point. I think we'll see that here. But that's just sloppy. We'll see that as we go through the Wisconsin jury instruction. Okay. Pull it up. So, jury instruction 800, self-defense, force less than likely to cause death or great bodily harm. That's non-deadly force self-defense. The jury instruction reads, self-defense is an issue in the case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed, that's subjective reasonableness, the defendant believed that there was an actual or imminent, that's obviously the element of imminence, unlawful interference with the defendant's person. Unlawful interference goes to the element of innocence, that it wasn't a lawful interference. They were not defending themselves against you. The next bullet point. And the defendant believed, again, more subjective reasonableness here, that the amount of force, that's proportionality, the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable. This would be objective reasonableness. Now, what's missing here? What's missing here is the element. So we've covered innocence, imminence, proportionality, and reasonableness. Avoidance is missing. That's only because Wisconsin has a distinct jury instruction on the element of avoidance. We'll get to that in just a moment. How do you determine whether or not beliefs were reasonable? A belief may be reasonable even though mistaken. And this is an important point, folks. We're not required to make perfect decisions in self-defense. We're allowed to make mistakes in self-defense, factual mistakes. We're allowed to misperceive a threat. Mistakes are permissible, and it could still be perfectly lawful self-defense so long as the mistake is a reasonable mistake under the circumstances. A hypothetical, reasonable, and prudent person would have made the same mistake. So a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. And that's all the circumstances, folks. In the case of Nicolae Miu, that's the chaos of the shouting and screaming at him. That's the circumstances of being in 15 inches of water, of being outnumbered, of knowing he's a quadruple bypass patient just a couple of years prior, that he's woefully unfit. This guy's probably a 180-pound frame. He's carrying 250 pounds that day on the river. When you see him in court, you'll see how much thinner he is than he was on the river. The circumstance that the people he's defending himself against are half his age and physically fit and young, and they're using the river against him. They're punching him into the water, pushing him into the water, and that the attack is sustained. The attack never ends until the people realize that he's stabbing them, which takes some time, which is one of the reasons for so many stabbing victims. Continuing, the reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. This is also a very important point on the facts of this case. The defendant's acts are the acts he was committing that are the basis for the criminal charge against which he's raising the legal defense of self-defense. In this case, that's the stabbings. The state makes a big deal about early in the cell phone video that Nicolae Miu jogs over to the boys in their rafts, and Miu says he trips. They say he, I guess, lunges. And he, in any case, goes down basically to his knees and wraps his hands on the tubes and supposedly touched the boy's legs. Now, Miu says that was all unintentional, that he tripped, he fell, he just put his hands out to support himself. And certainly he doesn't hold on to anybody's legs. He gets right back up, starts looking for the snorkel and the goggles he drops in the course of going to his knees. But the state tries to make a big deal out of that event, like that is a provocation or trigger for something. Nothing happens as a result of that event. And he's not charged with battery for that event. The state didn't charge him with unlawful touching of those boys' legs. And he's not raising the legal defense to that event. I mean, he wouldn't need to. There is no criminal charge. And he walks away from that event. He withdraws and communicates. So even if you believed it was an unlawful battery, even if you believed he'd lost innocence, and so wouldn't be able to justify that as self-defense, he recovers innocence when he walks away and walks downriver. He doesn't stab anybody then. He doesn't stab anybody until a new confrontation arises. So that whole grabbing onto the tubes thing and touching the boy's legs thing is legally irrelevant to the self-defense analysis here. The self-defense analysis doesn't arise until we're talking about the stabbings. That's what he's raising the claim of self-defense over. And perhaps arguably the battery on Madison Cone. Not the tube. The tubing thing is irrelevant. As the jury instruction tells us, the acts, the defendant's acts against which he's raising the legal defense of self-defense. There's no self-defense claim to the tubing event because there's no criminal charge to the tubing event. So that's non-deadly force self-defense. The big difference between this jury instruction and the deadly force defense jury instruction is we add the context of deadly force. Again, the big difference here on that element of proportionality is you can use force to defend yourself, but you can't use deadly force unless you're facing a deadly force threat. And that's what's covered in jury instruction 805. We just looked at 800. 805, privilege of self-defense, force intended or likely to cause a death or great bodily harm. That's deadly force. Death or great bodily harm. So you don't have to be threatened with death. Great bodily harm is enough to privilege you to use deadly force in self-defense. So it's very similar to the non-deadly force jury instruction, as you might expect. It's fundamentally the same elements. The only one that's different is the proportionality element, the requirement that now, because you're using deadly force in self-defense, that you were facing a deadly force threat. It reads, self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if, let's see, did I change it? Yeah. Only if the defendant believed, that's subjective reasonableness, there was an actual or imminence, unlawful interference, innocence, with the defendant's person, and the defendant believed, subjective reasonableness, that the amount of force used, that's proportionality, was necessary to prevent or terminate the unlawful interference, and the defendant's beliefs were reasonable. That's objective reasonableness. Now we get to the deadly force proportionality component. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to himself. And then they have the same requirements for reasonableness. You're not required to make perfect decisions here. You can make mistakes and still have it be lawful, deadly force self-defense, as long as your mistakes are reasonable mistakes under the totality of the circumstances, everything that was going on. Then we have the issue of retreat. So Wisconsin puts this in a distinct jury instruction. We looked at 800, non-deadly defensive force. We looked at 805, deadly defensive force. 810, the privilege of self-defense, the issue of retreat. It reads, there is no duty to retreat. So Wisconsin is not a duty to retreat state. It is a stand your ground state, but it's a soft stand your ground state. Because the jury instruction continues. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the unlawful interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. So 3 facets there. Could be done with complete safety. You're not required to increase your jeopardy in an effort to retreat. Retreat was practically possible. It can't be required if it's not practically possible. Here they say feasible. And you have to have known under the circumstances. So, for example, here, Nicolae Miu argues, hey, I had 13 people shouting and screaming at me, and a bunch of them were physically attacking me, punching me into the water, hitting me again, pushing me face down into the water. I was focused on the threats. I did not perceive an opportunity to retreat. And really, was there one? I mean, the state likes to point out before the fight happens, there's open water behind him, but he would have no duty to retreat then. This jury instruction doesn't say you have a duty to retreat then. It says you have no duty to retreat at all. And the only time the jury can consider the question of retreat is at the moment you're using force. So until you're using force, retreat's not on the table, even in this soft stand your ground state. So the fact that prior to him being involved in the physical confrontation, he might have had an opportunity to retreat, that's not legally relevant here. There's no duty to do that. And they don't have the authority to tell him to go anywhere when he's in a public place. He has the same authority to be there as those 13 people yelling at him. So that's retreat. Then we get to jury instruction 815 on provocation. So this is where, remember, we didn't really see the element of innocence very explicitly in the non-deadly self-defense and the deadly force self-defense instruction. It does mention that you're defending yourself against an unlawful interference, suggesting that the interference with you is not lawful. The other person's not using force against you in self-defense, for example. But now we get more into detail on what Wisconsin means by the element of innocence. So this deals with what Wisconsin refers to as provocation. Tells the jury you should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct, and that doesn't have to be criminal conduct. It could be tortious conduct, a civil violation. But a person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. So if you provoke the attack against yourself, you can't claim self-defense for your responding attack. If you lose the element of innocence, you lose the element of self-defense. If you provoke the fight, you've lost the element of innocence, you've lost self-defense. Except it's possible to regain innocence, even if you did provoke the fight. The jury instruction continues. However, first, it deals with escalation. The other party, you initiated a non-deadly force fight. The other party escalates unlawfully to deadly force. So you've provoked a non-deadly force fight. You've shoved somebody. Like Nicolae Miu says he shoved Madison Cohen, although he would say he did that in non-deadly force self-defense against her aggression. She and Riley Madison were already going hands-on with him. That's a battery against him. He's allowed to use non-deadly force to defend himself against their non-deadly battery. But even if you believe that was provocation, even if you believe he punched her in the face for no good reason, and we agree that would be a non-deadly provocation, if the attack which follows causes the provoker reasonably to believe that he's in imminent danger of death or great bodily harm, he may lawfully act in self-defense. So, even if he punched Madison Cohen, when they punch him into the river, all right, maybe that's fair. If they had stopped there, I don't think a reasonable person would have perceived an imminent threat of death or serious bodily injury, but they don't stop there. They attack again. They hit him again in the face. He gets to his hands and knees and they push on his back, face down into the water. They hit him again. This is a sustained attack. Nothing is stopping this attack, and it's coming from all different directions. From beside him, to in front of him, to on top of him, behind him. So if he reasonably perceives, under those circumstances, multiple attackers from young, fit men, 52-year-old quadruple bypass patient in 15 inches of water, more than enough to be drowned, he's already hit his head on rocks. If he reasonably perceives that he's facing an imminent threat of death or serious bodily injury, he regains the privilege of self-defense, even if he was the non-deadly force provoker, because they've escalated a non-deadly force fight. They've unlawfully escalated a non-deadly force fight to a deadly force response. Now, he does require some additional obligations. Even under that circumstance, he's not privileged to threaten or use deadly force in self-defense unless he believes he's exhausted every other reasonable means to escape. What this essentially does is it adds back in a legal duty to retreat, which he normally would not have, but which he requires because he was the initial provoker, even of only a non-deadly force provoker. Now, again, even here, that duty to retreat is contingent on being possible with complete safety. You're not required to increase your jeopardy and being practically possible. And now it suggests in these circumstances, safe retreat was not practically possible. Now, the other way you can regain innocence, even if you were the initial provoker, was if you withdraw from the fight and you give adequate notice of the withdrawal to the other party. I call this withdrawal and communication. Now, importantly, the communication doesn't have to be verbal. Verbal is best. I would urge you to do it verbally, loudly, so witnesses hear you, if you're planning to claim that you've regained innocence. But in most cases, the communication is actually what we call constructive. It's implicit in your conduct. So someone who's walking away from the fight is clearly physically withdrawing and also constructively communicating their desire to withdraw. They're not fighting from a distance. Again, we're presuming a non-deadly force fight here, like a fist fight. Now for the fight to happen, the other party, the initial aggrieved party, the victim of your push, who can file a charge of simple battery against you, you're on the hook for that. But now for the fight to continue, they would have to come to you, as these high school boys indeed come to Nicolae Miu after the tubing incident early on in the cell phone video. And if they do that, and then the fight reignites, they're the initial aggressors in that second force fight. They've lost innocence, and you've regained self-defense. So a person who provokes an attack may regain the right to use or threaten force if the person in good faith withdraws from the fight and gives adequate notice of the withdrawal to his assailant. And then they have a final form of provocation I refer to as provocation with intent. This is when someone's trying to fabricate the appearance of self-defense. This is the go ahead, throw the first punch, I dare you guy. He's not saying that because he wants to get punched in the face. He's saying that because he wants an excuse to use force against you, but he wants to make it look like self-defense. And if he wants to make it look not just like self-defense, but he wants to use it as an excuse to kill you, then he's what's called a provoker with intent. And a provoker with intent is treated more harshly than a common provoker. It's an aggravated form of provocation, and he is denied the ability to regain self-defense by withdrawal and communication. It's simply not an option on the table for him. And that part of the jury instruction reads, a person who provokes an attack, whether by lawful or unlawful conduct, with the intent to use such an attack as an excuse to cause death or great bodily harm to another person is not entitled to use or threaten force in self-defense. So Nicolae Miu had been shouting to these kids and the young adults, go ahead, punch me, I dare you, punch me, and then they throw a punch and he stabs them. That would look a lot like provocation with intent. That's not what happened here, of course. All right, so now with all that law under our belts, let's take a look at the cell phone video. And I'm not going to play it. I'm going to just move the slider. So there's no audio here. I'll play it in real time in just a moment, but it's easier to understand if we kind of break it down. Let's take a look at the polling, actually. So we have just about 1,500 votes, 85% not guilty. And the question is, based on the law and evidence, not what do you think the jury will do, but based on the law of evidence, if we presume a rational jury, Spock is on the jury, should the defendant be found guilty or not guilty? Guilty is 15%. Not guilty is 85%. Now, that's, of course, people who watch my content. That's the Law Self-Defense YouTube channel. God only knows what Law and Crime chat is saying. All right, so I'm going to end that poll, and I'm going to change the question. I'm going to put up a new poll. This is a different question. What verdict do you expect the jury to return? This allows for the emotions and passions of jurors and the unpredictable nature of jurors. So I'll put guilty. I'll have three options here: not guilty and hung jury. And I'll let that run in the background on YouTube. Somebody in the comments says Law and Crime is 50% not guilty. So 50% guilty. Oh, no, I guess it's 36% guilty. So double. The Law and Crime audience has double the guilty response as the Law of Self-Defense community. Well, because we're better informed on the actual law. So let's take a look at this video. So it starts at the beginning here. And I've slowed this down fourfold, but I'm not going to play it in real time. It just makes it easier for me to find individual points. So here's Nicolae Miu, filmed by Jawan Cockfield. He's sitting in his float. A bunch of the high school boys, the 6 high school boys, football players, are in their floats. Nicolae Miu's out in the water. He's holding his snorkel and goggle here. He's been looking for Ariel's cell phone. Now, obviously, Jawan Cockfield is filming him. So Jawan Cockfield has his phone up like this. It's in one of those waterproof bags. Nicolae Miu is looking for a phone, Ariel's phone, that's in a waterproof bag too. So he sees Jawan holding up this phone. The kids are already screaming and yelling. So there's no coherent communication going on. And Nicolae Miu jogs up to the boys. Now the state will say he ran at them. He's certainly moving quickly towards them. He's not simply walking slowly. And he gets close to them, and he basically goes to his knees. His hands go on the tubes, and the state says he touches the boy's legs. He says he trips and falls. He had broken up shoes. It's rough, stony ground, the bottom of the river here. And you can see the water's not super shallow. I mean, it looks like it's knee-deep over here. It's hard to move through knee-deep water, especially upstream, which is how he's walking. And he sees Nicolae Miu says, I see. And by the way, we should keep in mind, when there's all this self-defense, legal defense, once it's raised, the state has to disprove it. The defense doesn't have to prove self-defense. The state has to disprove self-defense beyond any reasonable doubt. And Corey Chirafisi did a good job on this on closing and explaining to the jury that, listen, you don't have to think it was probably self-defense. You can even think it probably was not self-defense, and that's still an acquittal. You could think there's a really good chance it wasn't self-defense, and that's still an acquittal. You could think, I'm almost completely convinced it wasn't self-defense, and that's still an acquittal. It's an acquittal on self-defense unless you have no reasonable doubt, not a moment of hesitation, that it wasn't self-defense. It's a heavy burden on the state. So every time we hear Nicolae Miu claims this and the state witnesses claim something else, the burden's on the state beyond a reasonable doubt. Nicolae Miu is presumed to be innocent until the state has overcome Nicolae Miu's arguments beyond any reasonable doubt. Hard burden if the jury does it right. So Nicolae Miu, he jogs up to the boys here. He's moving about as quick as I think you could expect. See, the water's, I'd say it's really just above his knees here. Look how fat he is here. He gets up there. He puts the goggles and snorkel in his mouth, and he goes down to his knees. He says he tripped. Hands go on the tubes, maybe touches legs here. He drops, right there, he drops his snorkel and goggles into the water. He reaches down for them, but doesn't get them. They're gone. The boys are yelling and howling. He's looking for his goggles in the water, doesn't find them, stands up. He doesn't strike the boys, doesn't kick them, doesn't stab them. He's just standing there, not doing anything physically aggressive. Even if you believe the lunging at the tube was physical aggression, even if you believe it was a simple assault, put the boys in fear of imminent harm, or it was a battery, the touching of their legs was an intentional offensive contact. He wasn't charged with any of those as crimes, by the way, by the state. But even if you believe that was the case, or this could have been characterized as some kind of provocation, Nicolae Miu, so provocation would have lost him the element of innocence. He walks around to the downstream side of the tubes, goes in the water, looking for his goggles and snorkel again. So he's moved away from the boys. They're moving here to him. He turns his back. He's not engaging the boys either verbally or physically. He's walking down the river. He's creating distance. He turns back and he points. I don't know what he's saying, but he continues downriver. Look at the distance that's created here. He's created that distance. The river is 150 feet wide here. There's no reason the boys can't just float past him if they want to do that. And then, of course, if he acted physically aggressive, they could defend themselves against that. But they don't want to do that. They've targeted him now, calling him a pedophile, a raper. He's looking for little girls. They're shouting at the top of their lungs. Lots of laughing, lots of big smiles. They're moving towards him. Everyone's having a good old time, everybody except for Nicolae Miu. I believe that's Isaac Shuman in the white hat there. I could be wrong about that. But you can see these boys are all physically fit. They're not 12-year-olds. They're 17-year-old high school football players. Oh, that's Shuman. That's Isaac Shuman. That would be the fatality right there. Does he look terrified? Does he look in fear? In any case, the boys are closing on Nicolae Miu. He's not closing on them. So even if he did act with provocation and lose the element of innocence when he touched the tubes, touched the boy's legs, what has he done? He's withdrawn and effectively, constructively communicated his desire to withdraw. He's regained innocence. Now, the state could have charged him with assault, simple assault or simple battery for the tube event. They didn't. And I think the reason they didn't was because they didn't believe they could prove beyond a reasonable doubt that he hadn't simply tripped in his crappy shoes. So this incident is now over. Nicolae Miu has walked away. The touching the tube and legs incident. He's walked away. It's over. Now for the confrontation to continue, it needs to be reignited by these boys closing proximity on him. And with all their shouting and rapist, raper, pedophile, looking for little girls shouts, it attracts the attention of another group. So far we've been talking about G1 and the 6 high school boys. These are the 6. RN, LM, IS is Isaac Shuman, who would suffer fatal injury. AV, OP, and JC is Jawan Cockfield. Those are the 6 high school boys. Jawan Cockfield is the one recording the video we're watching here. He's immediately behind the people coming over from Group 2. Group 2 is the Carlson group. They hear the shouts of pedophile. Quentin Carlson, the father, the head of G2, tells his 2 adult sons, Dante Carlson and is it AJ? No, AJ Martin, Anthony Carlson, DC and AC, to walk over there. He testifies in court, the father does, because he's afraid that the 6 high school kids are going to beat the brakes off the old man by himself, being confronted by them, that he's going to take a beating. So he's concerned about the safety of the defendant. Does that contribute to the defendant's argument that he had a subjective fear? Sure, of course it is. Other uninvolved observers also had that fear for him. So the first couple of people over are actually 2 women, Madison Cohen, MC, and Riley Madison. 2 women, the state would repeatedly say, well, he was only facing 2 women. Does it look like he was only facing 2 women? Now, it's true that in most of the early parts of this video, because of the position of Jawan Cockfield, his camera only captures the 2 women in its field of view, and then the defendant downstream. And the state will say, look at all the space he had downstream to go. But the defendant's own group of people was to the bottom left of this image, like where my tie is. So if he's walking downstream, he's walking away from safety. And you'd have to believe this 250-pound quadruple bypass patient could run downstream faster than the high school football players could chase him down. Remember, they're already following him. They're pursuing him. They went to him. And now this new group of young adults is coming over as well. We see that here. So now I would argue we have a new confrontation. The tube thing is over. And a new confrontation happens when the high school boys pursue Nicolae Miu downstream and G2 comes over. Group 2 comes over. Now, Nicolae Miu would testify, well, I saw that these people were older, like adults, and they were, in fact, adults. So I was hoping I could reason with them. So here comes Madison Cohen walking over, and Nicolae starts walking in her direction. There he is, walking over to her. She doesn't want to reason. She's drunk. They're all drunk. She's got a beer in her hand, a vape in her other hand. And, you know, sometimes people vape tobacco products and sometimes they vape other stuff. There was definite marijuana use on the river. We had testimony about that. She's just screaming at him to go away and pointing downstream, which again, downstream would be up in this image here on the screen. I forgot to bring her back up. Let me fix that. So back to the river here. So Madison Cohen starts walking over. We see her here. Nicolae Miu says, oh, adults. I can reason with adults. He starts walking over to her. We see that here. But she's not interested in reason. She just starts ordering him, the queen of the river, Madison Cohen, starts ordering him, you walk downstream. You walk that way. Just get out of here. I don't want to talk about it. She's cursing at him, screaming at him. He's already being screamed at by the boys behind him. Of course, they're all laughing and giggling and calling him a pedophile. Look, they're pointing. There's Jawan Carlson pointing. He's looking for little girls. Who likes pedophiles? Is it safe to say nobody? So they're characterizing him, Nicolae Miu, as someone who everyone should hate, right? Are there plenty of people out there who'd be comfortable, feel justified in using violence against an identified pedophile? Should that escalate this defendant's fear that he's being characterized by a mob of howling hyenas as a pedophile? What if this new group believes this? And apparently they do believe it because they're simply shouting and ordering him away. He gets criticized, Nicolae Miu, for not engaging in more communication. How do you communicate at the River Queen who's telling you to get the F downriver? He tries. He's trying to explain. He gestures upriver to his own group at least twice. He's like, hey, guys, if somebody could come over here. And they do start to come over. Ariel, who'd lost his cell phone, he starts to walk over. But he's just, you know, there's no violence taking place yet. He's taking his time. Nicolae Miu's turning his back on these people. He's not trying to be confrontational. He's not shouting back in her face. He's not pointing his finger in her face. He's really just not engaging, but getting nervous. More people are coming. The crowd's getting bigger. Everyone, including the adults, see he's waving to his own group there upriver. And then when he does that, Madison Cohen waves to her group. She wants allies there too. So more people from her group start coming over. There's one of the Carlson group guys. I think that might be Dante. I do get him mixed up right there. He's going to be the one who punches the defendant into the river. Does he look friendly? He's just trying to figure out what's going on, make peace. That's how the state will characterize him. There's Madison Cohen. Look, she's waving to her group. Come on, guys, come on, come on. Because she wants this, right? Madison Cohen wants this. She wants allies from her group backing her up. And there's already the 6 teenagers. So now we end up with 13 people arrayed against this defendant. And they're between him and the safety of his own group. They don't know that, but he knows that. And what's relevant in self-defense? His subjective belief and whether or not that belief is objectively reasonable. And when I play this in real time, you'll see how chaotic this scene really is. You kind of lose some of that because I don't have the audio playing, but it's easier. It's very distracting, just like it would be distracting for Nicolae Miu. Now, all that open water behind him, that's downstream. Now these high school kids are getting between him and even downstream as a position of safety. But all the aggressors are upstream. They're behind him. He's not required to attempt to flee unless he can do so with complete safety. Does it look like he is a completely safe avenue of retreat? And would he know that? Look at how terrified all these kids are. Everyone's laughing, pointing. If they were afraid of Nicolae Miu, wouldn't they create distance from him? I mean, certainly they can. No one's blocking them from moving to another point in the river. Now we have Riley Madison, sorry. Riley Madison, hands-on, touches, unwanted offensive touching of Nicolae Miu. This is a simple battery. It's unlawful. It's a crime. She could have been charged with unlawful battery here. And Nicolae Miu is legally privileged to defend himself against unlawful battery. Now, this is non-deadly force, so Nicolae Miu would be limited to using non-deadly force to stop this. And, of course, she's not the only one. He says he grabs her arm, pushes her. That's her with the arm tattoos there, Riley Madison. There's Madison Cohen screaming. All the witnesses said she was in his face. Sorry, just want to make sure nothing was happening in court. The news feed is playing the rebuttal, the state's rebuttal from yesterday, which was terrible, but thankfully short. But it's all good. So he's looking, the defendant's looking back towards his group again. Now Riley Cohen and Madison are touching the defendant. Let's see. There's the hand of Madison Cohen on the defendant. Again, now two people committing simple battery. And the state kept saying, well, it's just two girls, just two little girls touching him. But is it? We see the Riley Madison circle. We see the Madison Cohen circle. Who's immediately behind them filming? Jawan Cockfield, who 2 years after this event is playing college football and college wrestling. He's not a small dude. These 6 other high school football players at the time, Dante Carlson and Anthony Carlson and A.J. Martin, all of whom are young adult men who would physically attack this defendant before they knew he had a knife. None of them knew he had a knife when they're going. They think they're giving an old man a beatdown. When he strikes them with the knife, they think they're getting punched. They don't know that they're getting stabbed until they see their injuries. And then from this flank, of course, Isaac Shuman would ultimately attack the defendant as well. So back to the cell phone video. What is the defendant's reasonable perception here? He says he had a subjective, genuine, good faith belief that the threat against him was escalating. Things were getting hotter. He's still not stabbing anybody here. He does end up taking his knife out of his pocket. We'll see that in just a moment, and opening it up. He doesn't brandish it. He keeps it at his waist. The state will try to argue that that was a bad thing for him to do. He should have brandished the knife. What do you think the state would have done if he brandished the knife? They would have called that unlawful brandishing, unnecessary under the circumstances. Because let's face it, if he'd brandished a knife, they probably wouldn't have attacked him with their bare hands. They would have backed off from the knife. And then they would have characterized Nicolae Miu brandishing the knife as unlawful use of a weapon, unlawful threat of deadly force against them. Aggravated assault with a deadly weapon, a felony. Plus, of course, it could escalate things, right? So he's not brandishing. The state will say, well, he should have brandished. He should have let him know he had a knife. They could have seen he had a knife. It's clearly visible. So I want to see if I can find the knife in his hand before that punch happens. I've seen it in other clips. I think it's covered up by that little gray bar at the bottom. Sorry about that, but the source of this had letters down there. But he does have the knife out at this point. It's in his hand by his side. And the girls are in his face. They're touching him. They're pushing him. They're grabbing him. We all see the contact in the image. Then the camera pans away here. And it's at this moment that it's claimed that the defendant punched Madison Cohen. The defendant says, I raised up my left hand, to create space from her battery. And that could be true, and it might have been mischaracterized. Maybe she took real offense at him touching her, made it seem like a punch. The state says she was punched into the river. But when the camera pans back, this is her. She still has her beer. She still has her vape. She still has her cell phone tucked into the top of her bathing suit. She's not wet. She hasn't been punched into the water. She has no indication of injury. And of course, Nicolae Miu says, I did not deliver a hook into her hand. The witnesses couldn't even remember if he punched her with his right hand or his left hand, what side of her face was hit. No visible injury. No police officer who interviewed her that day noted any kind of injury. You think they would have, right? In a homicide case. They knew it was a homicide case. They knew Isaac Shuman was dead. No medical report, nothing. So, in response to either the perception or the belief that Madison Cohen had been punched, some kind of contact had been made, one of the Carlson boys punches the defendant into the ground, right into the water, right there. Bam! He falls down, falls backwards on his back. He says he hit his head on river rocks, 15 inches or so of water. And if they had stopped there, they would have had a pretty good claim of self-defense for throwing that punch. Hey, I thought Madison Cohen had been punched by this guy. Maybe she really had. So I punched him. I used a non-deadly force punch in defense of others, in defense of Madison Cohen, in defense against the non-deadly force used by this old man against Madison Cohen. That might have been fine. The trouble is they don't stop there. They hit him again. Right there. Bam. To the head. He turns over, gets on his hands and knees. They push on him from the back. This is A.J. Martin, who would end up disemboweled. While he's on his back, he gets hit in the head again. Now, when he's finally able to come up, he's got the knife in his right hand, and A.J. Martin lunges at him. The defendant's not going to A.J. Martin. A.J. Martin's lunging at the defendant with his hands up at the defendant's neck. The defendant simply holds the knife out, and A.J. Martin basically hurls himself onto the knife. And as the defendant falls back into the river again, the knife moves up. The state says intentionally. The defendant says unintentionally. I wasn't trying to raise it up. I was falling backwards. And disembowels A.J. Martin. So he would be laying in the river with his guts hanging out. But it takes a moment or so for people to realize that's happened. You can clearly see the knife in his hand there. A.J. Martin is like WTF, falls in the water, and his intestines start coming out of his body. But it takes some time for people to realize that. The defendant is knocked back into the water again by this A.J. Martin lunge, gets back up, knife in his right hand again, and more people come at him. Now, this guy is one of the Carlson group. The state characterizes him as a peacemaker. He's trying to separate people. Of course, there's still lots of yelling and screaming going on. We'll hear that. He's pointing, get back, whatever it is he's saying. And then he goes hands on to the back of the defendant. So the defendant's already been subject to these attacks. Is it possible that this young man is in fact a peacemaker and doesn't intend to threaten this defendant, to cause him any injury? Sure. The defendant maybe perceives it as a threat mistakenly. Does that mean he can't defend himself against it? No. As we know from the jury instruction, reasonable mistakes are permissible. From the deadly force jury instruction, deadly force self-defense jury instruction. A belief may be reasonable, even though mistaken. Even though mistaken. So the defendant's just been attacked, shoved in the water, hit, pushed face down into the water, hit again. Now, Riley Madison has been stabbed here. I've always had trouble seeing where that happened. It's not, I don't think it's captured on the video. But the defendant's not chasing anybody here. There's the first stab, I believe. Right? Yep. Let's see. There's this hit to the face. He gets up, charged to the neck. Hands go right to the neck by A.J. Martin. Back into the water. That's Riley right behind the defendant there. It's never been clear to me exactly how she gets stabbed. She gets stabbed in the side. That's her in the bikini bottom. He comes back up. The peacemaker. And Riley's already been stabbed there. And she looks like she's walking away. But we don't see the defendant going anywhere. He's standing in place. So I would suggest that she closed on him. The hands go to the back here. Could this be reasonably perceived, even if mistaken, as a continuation of the deadly force attack upon him? Yes. Of course. So this guy gets stabbed. We can see Riley's already stabbed. That guy gets stabbed. Little jab with the knife. Another shove. And all to the neck again. Hand to the neck. Shove back hard. Another stab there. Now people are beginning to realize there's a knife in play. The guy with the American flag shorts and the dark top, that's Ariel. That's his friend that's the defendant's friend from his own group, is finally there. But at this point, the fight's all over, except for Isaac Shuman. Or has that happened already? Let's see. Where's Isaac? I guess it's happened already. Let me see. There's Jawan Cockfield. Turns the lens to himself. Somewhere here, there's an image of Isaac lunging at, again, with his hands on the neck of the defendant. Maybe that's him at the end there. There's A.J. Martin in the water. Yeah, that might be Isaac right there. And the knife comes up from below, penetrates his chest, nicks his heart, and that's the fatal injury right there. So through all this, could this defendant have a reasonable perception that he's facing an imminent threat of death or serious bodily injury from this group attack on him? Yeah, for sure. And more importantly, can the state disprove that claim beyond any reasonable doubt on these facts? The defendant doesn't stab anybody who doesn't go hands-on with him, who doesn't present himself in a way that could reasonably be perceived as a continuation, or actually is a continuation of the attack. All right, now let me play the video in real time with the audio so you can hear how chaotic it was in an audible sense. Ready?
That's cracking. What is he on? Whoa! 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 Where's your way? Oh, God! We up! We up! What are you talking about? What the hell are you talking about? What?
Get away from us.
What?
I mean, it would be pretty difficult to describe this tube event as an assault, which would require that he put the boys in reasonable fear of imminent harm when they're all laughing and chortling. No one sounds afraid here.
What's going on with y'all homie? He's on camera.
Guys, let's go.
Tripping. He's on 14. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. Further culture. Who is that? Further culture. Who is that? Who the hell is this?
Bro, doesn't matter.
He said he was looking for a little girl.
You're looking for a little girl.
Yeah.
That's exactly what he said.
Weirded us out. I didn't have that part on camera, did I?
Some young ass kid.
What the hell is this guy's problem, bro? We're trying to have fun. If he's gonna claim you, he's gonna claim you. We don't want this one. Get on camera. Oh God, He hit a woman? He hit a woman? You hit a woman. He hit a woman. You got him. What the fuck? What the fuck? What the fuck? He's dying. He's dying, bro. What? Oh my God. Oh my God. Oh my God. Are we serious? Is this real? Oh my God. Who is that? Oh my God. Oh my God. Is this real? Is this real? Oh my God. Oh my God. What the fuck? Is this real? That's not bike! That's not bike! That's not bike! That's not Isaac! Oh my God! Oh my God! This isn't real! This isn't real!
So that's the video. Now, when the defendant, so bad stuff for the defendant, mostly consciousness of guilt type of evidence. He eventually gets out of the river. Everyone's getting out of the river. There's a little bridge in the background there. The police are waiting on that bridge. People are getting out of the river. He doesn't approach police. Now, he had heard there's a man walking around the woods with a bat looking for whoever did this. He's worried about that, but he doesn't go to the police. The police essentially have to go to him. They get a screen capture from this video of him, and the police are using that. They see him in the crowd. They approach and make an arrest. And he pretends in the patrol car that he doesn't know what happened. He heard there was a stabbing, and he matches the description. When he's interviewed at the police station by investigator Brandy Hart, he makes up a story about how they attacked him with a knife. He used their knife against them. He took a knife away from them. Just a big pack of lies, basically. And that's consciousness of guilt evidence, because in the sense that it's essentially evidence tampering, right? You're making up a story of evidence. You're fabricating evidence. Why wouldn't someone who believed they acted in unlawful self-defense simply explain what happened truthfully? So that kind of evidence can be used against you as consciousness as guilt evidence. It tends to be relevant and damaging in circumstances where we don't have objective evidence about what happened in the fight. So if there were no video here, if it was just the word of this defendant, Nicolae Miu, and the 13 other people, and he spends an hour lying to the police, you'd say, well, he spent an hour lying to the police. We can't believe anything this guy says. We can't believe any part of his narrative about what happened in the river. We're going to believe the other people. And that he'd be doomed if there were no video. Ironically, the video from the source of the video is the people who attacked him, who he defended himself against. So it can undermine the credibility of the defendant claiming self-defense, be extremely damaging. But that's not the case here, because here, of course, we have the video. So if you have a hypothetical situation where there's a use of force claimed as self-defense, and you know for absolute certainty all the elements of self-defense are perfectly satisfied, it was lawful self-defense as a factual matter, right? Let's pretend we have that hypothetical situation. All right. It looks like we have a verdict. Let me pull up the news feed.
Side that, of course, in the death of in the death of Isaac Shuman, you go down from there.
We don't know what the verdict is yet.
And then those reckless homicide counts of bottom three evolving over the last 48 hours with the state adding so-called lesser includeds. Your thoughts as a jury has reached unanimous decision on those counts, and then here the survivors, those stabbed that day. I just wonder what's going.
By the way, my most recent YouTube poll, what verdict do you expect the jury to return? Not what's the legally sound verdict, but what do you expect from the jury? It went from like 85% not guilty to 56% not guilty. Guilty went up to 25%, hung jury 20%.
Jury is knowing what murder one is, that the consequence of that, whether it's life or death in some states, that that's something they're not going to reach lightly, and they're going to debate that and redebate.
Marsh, we got to cut you off. The judge is already on the bench. The judge on the bench, Michael Waterman, is in court. The defendant's there. He's now to the left, on the other side of Aaron Nelson, left side of his defense attorney. The jury is coming in. A verdict has been reached. We should hear Nicolae Miu's fate in mere moments.
All right, please be seated. All right, we are back in session on the record in state of Wisconsin versus Nicolae Miu. The attorneys are present with Mr. Miu. 12 jurors are in the courtroom. Mr. Ashland, I understand you are the foreperson.
Correct.
Did your jury reach a verdict?
Yeah.
Did you reach a verdict on each of the 6 counts?
Yes, we did.
Okay, please hand the verdict forms to the bailiff. Verdicts read as follows. As to count 1 of the information, Isaac Shuman, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Question, did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes.
That's all.
As to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 3 of the information, Dante Carlson, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 4 of the information, Anthony Carlson, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 5 of the information, Riley Madison, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes. As to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Did Mr. Miu commit the crime while using a dangerous weapon? Answer, yes.
What?
Members of the jury, I do have to verify that this is in fact a unanimous verdict.
That last one's insane.
So I'm going to ask each of you if I correctly read the verdict and if you agree with it. So when I call your name, if you agree with the verdict that I read, please answer by saying yes. If you disagree with the verdict, you can answer by saying no. Ms. Navarro, do you agree with the verdict that I read?
Oh, we gave her name out.
Mr. Cook, do you agree with the verdict that I read?
Yes.
Mr. Snell, do you agree with the verdict that I read?
Yes.
Ms. Pelzel, do you agree with the verdict that I read?
Yes.
Mr. Wiley, do you agree with the verdict that I read?
Yes.
Ms. Knapp, do you agree with the verdict that I read?
Yes.
Mr. Diedrich, do you agree with the verdict that I read?
Yes.
Ms. McMahon, do you agree with the verdict that I read?
Yes.
Mr. Henderlong, do you agree with the verdict that I read?
Yes.
Mr. Ashland, do you agree with the verdict that I read?
Yes.
Ms. McMullen, do you agree with the verdict that I read?
Yes.
Ms. Lewandowski, do you agree with the verdict that I read?
Yes.
Any additional polling? No? All right. It is a unanimous verdict. Members of the jury, your service in this case is completed. You are free to read accounts about this trial. You are free to talk about this case with anyone. However, you do not have to discuss this case with anybody or answer any questions about this case other than from the court. So this includes the parties, the lawyers, the media, or anybody else. If you do decide to discuss this case with anyone, please treat any such discussion with a degree of solemnity, such that whatever you would say, you'd be willing to say in front of your fellow jurors or here in open court. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or the public. For that reason, please respect the privacy of the views of your fellow jurors. If you do decide to speak, please only speak for yourselves and not for anybody else. On behalf of my colleagues, Judges Needham, Vlack, and Nordstrand, along with my courtroom staff, thank you for your participation in this important case. Court is now adjourned. Please take the jury out.
All rise for the jury.
There we go. Juries are dangerous and unpredictable creatures, folks.
Please be seated. Based on the unanimous verdict, I will enter convictions on each of the 6 counts. Bail is revoked. Mr. Miu will be held in custody pending sentencing. My staff will contact the attorneys and will schedule the sentencing date. I will order a pre-sentence investigation report, but we can do the scheduling at a later time. Is there anything else, Mr. Anderson?
No.
Mr. Shroffasy?
No, sir.
All right. Thank you, everyone. Court is adjourned.
Folks, if anybody on this side of the courtroom could please exit, anybody on this side, please stay.
Each side of the courtroom is for defense or for the state, basically. So they want them to leave separately so there's no fights. How about that? How about that? 85% the law self-defense community believed it should be not guilty on the law and evidence. That's certainly what I believe.
And
I
good
didn't think the
morning
state
again.
had
I
come
am Paul Bloom,
close.
Fox 9 News, here as we approach 11:15.
All right, that's all I need to hear from them. So, guilty on all counts. I'll put another poll up. I wonder what the results will be on this one. Oh, what happened to my chat? Show chat. Guilty on everything. Nicolae Miu is going to prison forever. Forever. Let's see. Nicolae Miu found guilty of all charges. Just verdict. Unjust verdict. I'm going to add a third one. Insanely unjust verdict. All right, new poll. New poll up on YouTube. Nicolae Miu found guilty on all charges. Just verdict, unjust verdict, insanely unjust verdict is choice 3. What do you think got him? I mean, it's crazy to me that this is a unanimous jury, only a few hours of deliberations. I mean, they didn't spend a lot of time talking about this. Yesterday afternoon, and then what, a couple of hours this morning? What do you think got him? You think it was the lies to the police afterwards? The consciousness of guilt evidence, despite the video evidence? I suspect that part of it was the grievous nature of the injuries, especially to A.J. Martin. If there had been less severe stabs, I think it would have appeared much more favorably to the jury. When you literally disembowel someone with a knife, now, strictly speaking, in the eyes of the law, it doesn't really matter how much deadly force you use, as long as the conditions for the legal use of deadly force have been met. So if someone's trying to kill you and you use a knife and you disembowel them, that's not really different than if you just jab them once with a knife in terms of the justification of your use of force. But it looks a lot worse. It looks a lot worse. There are expert instructors in knife defense that I know who will advocate for, learning techniques with a knife where you're actually causing relatively modest but functionally impairing incisions with a knife. So tendons in the wrist and the arm, as opposed to disemboweling somebody with the knife. In part because it can be more effective as self-defense. You're actually removing function from people. I mean, obviously disemboweling would take you out of the fight for sure, but some of these other people were stabbed seriously, but maybe not enough to take them out, like if they had a gun in hand. The minimal amount of force you can use consistent with winning the physical fight is what you want to do. And of course, we don't know, at least I don't know. I'm not in Wisconsin, so I haven't been watching the 2 years of media coverage of this event. We don't have a good sense of how toxified the local jury pool might have been. I hear this town is like 15,000 people. Maybe the whole county is 15,000 people. I don't know. But that would be a small community. And 5 of their young people got stabbed by this guy with a Romanian accent who's got no kids of his own. So there's nothing wrong with Nicolae Miu having no kids of his own, but it would mean like he's not known as a parent, right? Parents wouldn't know him. Him and his wife and his dog are the unit. You think this might have an effect on the popularity of tubing on the Apple River in Wisconsin? Would you go there? Knowing that if you're subjected to what Nicolae Miu was subjected to and you defend yourself with a knife, you're going to prison for the rest of your life, even if it's caught on video? I would have been less surprised by a finding of maybe guilty on the Riley Madison stabbing, because it's not clear to me on the video what she was doing that earned her that stab wound. I could see in the totality of the circumstances how she could be perceived as, part of the ongoing attack, but I didn't see that part on video. But there was no distinctions being made here. Every person who was stabbed, it's a guilty verdict. And the insane one is the battery on Madison Cohen. She wasn't stabbed. The most anybody claimed was that he punched her. He didn't punch her with a deadly weapon. Unless you believe the knife was in his, but he didn't use the deadly weapon. It's completely incidental. That only adds 6 months to the misdemeanor charge. So, what are we looking at for sentencing? I've covered this before, but I'll cover it now. They're going to do a pre-sentence investigation, appropriately enough. Let's see. I think I have all this fixed now. So it almost doesn't matter, right? Because he got the conviction on the first-degree homicide, which is a mandatory life sentence, minimum life sentence. So it doesn't matter about the others, except in an academic sense. So life for the first-degree homicide. Let's see. Let me look at my notes here. If I captured this all, I'll have to double check it. It was coming down pretty fast. It looked like it was all the first-degree reckless endangering. So each of those is good for 12 and a half years, plus 5 years for the knife. So we're up to what? 50 years for the non-fatal stabbings, lifetime for the fatal stabbing. So it's life plus 50 plus 5 years for each of those. So that's another 25, life plus 50 plus 25. So now we're up to life plus 75 and 9 months plus 6 months. So a year and a quarter for the battery with a deadly weapon on Madison Cone. I think that maybe the jury just bought the he should have walked away earlier argument. I knew this would be dangerous for the defendant when they went over the jury instructions. Those of you who are watching my jury instruction show know that I was very worried about those jury instructions. They were very favorable to the state because they allowed a lot of opportunity for confusion. Now, I didn't think it would result in a guilty verdict, but I thought it might be enough if you had one or two jurors. If you have one or two jurors who were looking for a path to conviction, that they might latch on to the ambiguity left in the jury instructions by this judge over the objection of the defense, latch onto that to end up with a hung jury. And then, of course, you're just trying this guy again in another couple of years. But that every juror unanimously would arrive at a guilty verdict really, really does surprise me. I have to wonder to what degree it was because of a politicized, propagandized, poisoned jury pool over the last 2 years. I mean, how many interviews with the stabbing survivors? How many interviews with the parents and friends of Isaac Shuman? The teary television interviews, the news reports, how they're recovering. When they graduated from high school, you think this was a topic of news? Poor Isaac didn't graduate. He didn't make it because that Romanian guy killed him on the river. This is our river. This is Wisconsin country. This is beer in one hand, vape in the other. Get the F out of here, you pedophile. What about an appeal? So, yeah, forget it. So, appeals are for losers, right? I mean, you only appeal if you lose a trial. Nicolae Miu has now lost a trial. So, of course, that's why he would appeal. Plus the prospects of meaningful relief. And meaningful relief is not that you're found not guilty by the appellate court. It just means you're given a new trial. And they would need a reason to do that. So to have any prospect for meaningful relief, 3 things have to be true. One, the appellate court has to believe that whatever the appellant now, whatever Nicolae Miu was claiming as a legal error, because they'll only look at legal errors. So factual errors, that's up to the jury. The jury decides the facts. The jury could do that wrong. Nobody cares. As long as there was some evidence to support the jury's conclusion, and there was. I think it was nonsense, but there was testimony put into evidence by the state. I think many of us who watched those young men and testified heard a lot of lies in their testimony, things not supported by any objective evidence that was self-serving. But the jury is allowed to conclude that they believe those witnesses in their testimony. So anything having to do with a finding of fact, the appellate courts are going to completely defer to the jury. So the appellate courts would only be looking at errors of law. The errors of law, the things we saw objected to, and there were quite a few objections in this trial, were like the form of questions by the state or mischaracterization of evidence by the state. But again, that goes to fact, and the jury decides the facts. The judge rules on those, but trial judges have almost utter discretion on those kinds of rulings. remember, the appellate court judges almost always used to be trial court judges, and they got promoted out of the trial judge job. They don't want to do trial judge work anymore. So they're going to give almost complete discretion to the trial judge on those kinds of evidentiary rulings and decisions. In terms of the jury instructions, it sounded to me like the judge found a safe harbor for himself. I think the defense made very compelling arguments that the jury instructions, as written, left a lot of room for ambiguity and confusion, but they are as written. And that's a safe harbor for the judge. You can always safely rely on the standardized jury instructions as they're written. You create risk for yourself as a judge by agreeing to modification of those jury instructions. So every time the defense asked for a clarifying modification, which I think was justified, the judge said no. I think that's how the jury instructions are written, and it's easier for me to leave them the way they are. It's a correct statement of the law, even though it may be a correct statement of the law to a legal technician like the judge, but not necessarily to a lay audience of jurors. It would be interesting to hear an explanation from jurors how they arrived at this conclusion of guilty on every count. I'm always skeptical of what jurors say after a verdict, especially if they acquit, because often when they acquit, they go home and they take heat from their community for having let, some propagandized defendant off the hook. And so they'll make up stories like, oh, I was fooled by the defense, or if I'd seen this other evidence that was excluded, I would have convicted. So they're always hard to believe when they acquit. When they convict, it would be interesting to hear what they say. I'm not sure, not necessarily believe it, but it would be interesting to say if it was an emotional decision, or if they relied on stuff that's actually technically legally irrelevant. So, yeah, I don't think I'm going to Wisconsin anytime soon. Certainly not going tubing there. All right, so let me take a look at the comments. Actually, before I do that, just want to remind everybody that today's content is sponsored by Law of Self-Defense in the form of our upcoming Law of Self-Defense Advanced course. Saturday, April 20th. We only teach this class twice a year, folks. We teach it live, twice a year, streamed to you at your computer, taught, of course, live by me. The next one is Saturday, April 20th. It'll be October at best before we do it again. Teach you everything you need to know in order to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. We talk about defense of self. We talk about defense of others, your family, your neighbors, your colleagues, strangers, like an active shooter event. We talk about defense of property, the many forms of property, highly defensible property like your home, temporary, highly defensible property like a hotel room or an RV or a tent if you're camping. We talk about least defensible property like your stuff. Your pets are least defensible property. We talk about consciousness of guilt evidence, which may have gone a long way to getting this defendant convicted. We talk about self-defense immunity. We talk about interacting with the police in the aftermath of a use of force event. Again, would have been extremely helpful to this defendant to have taken this class before he went tubing, July 30th, 2022. If he had done so and followed what I teach, he would not now be facing almost certainly a life sentence in prison. I don't think the judge has any discretion on the first-degree homicide charge. Minimum is life in prison. Learn more about it at lawofselfdefense.com/advanced, but I would urge you not to delay. And if you have a conflict on April 20th, sign up anyway, because we'll make the recorded playback of the class available to all the students for 2 weeks after the live class. So you can watch it at your leisure over that 2-week period. Otherwise, you're waiting at least another 6 months before you have another opportunity. And do you know when you'll be attacked? Did Nicolae Miu know he was going to have a bad day that morning of July 30th, 2022? He didn't. You need to have this information, insight, expertise on board before the fight happens, folks. Your lawyer afterwards is stuck with the facts you give him, like Nicolae Miu spending hours lying to the police, lying about the knife. So you need your lawyer stuck with what you give him. Give him good facts and you're hard to convict. Give him bad facts and it's a very difficult defense. So lawofselfdefense.com/advanced. And this is the last week, and today's Thursday. So the last week for the early registration, 50% off if you sign up this week. Check it out. We have if you go there, lawofselfdefense.com/advanced, we have a list of more than 100 very specific self-defense law questions we answer in plain English. It is live. There's plenty of opportunity for Q&A. Sometimes we end up with hours of Q&A. And although when that's the case, I usually I end the class at a reasonable period and then follow up the Q&A on successive days and make it available to the students. You should expect to be there for 6 or 7 hours. It's a full day class. All in one day. You learn all this stuff in a single day, folks. Or watch it over the following 2 weeks if you'd rather watch the recorded playback. Again, all of that at lawofselfdefense.com/advanced. So I'm going to look now at the questions and comments. First of the Law of Self-Defense members, they get theirs answered for free. And then I'll turn to YouTube. But if you're posing questions on YouTube, it needs to be a $10 minimum super chat. That's the price you pay for not being a Law of Self-Defense member. All right. Let's see what we have. Well, it looks like it starts with the verdict is when most people came in. People, I'm not going to name everybody. A lot of these are short, but a travesty. This jury should be ashamed of itself. Stay the heck out of Wisconsin. Disagree with the verdict, but shows you were always at risk with the jury. Yes, when I tell all of you that the risk of conviction is never zero, just like the risk of the physical fight is never zero, right? You might learn how to shoot a gun or use a knife or carry pepper spray or study jujitsu, and you do all those things so that you get your risk of losing the physical fight to as close to zero as possible. That's a good thing. I do all those things to get my risk of losing the physical fight as close to zero as possible. But the risk is never zero. It could not be your day. Just lose that fight. And losing the fight could mean death. Well, the same is true for the legal fight. You can get the risk of losing the legal fight darn close to zero. That's what we teach at Law of Self-Defense. But the risk is never zero. Once you get engaged, go hands-on in that fight, you've just incurred a greater than zero risk of death and a greater than zero risk of going to prison for the rest of your life. Like Nicolae Miu. Now, there is a concept called preclusion. Preclusion is not an element to self-defense. You're not required to do that to qualify for self-defense. But is it prudent? So, like we heard from one of the party in Nicolae Miu's group, right? Eric Von Williams, was it? Eric Von William, the black gentleman in his group, who testified he was uncomfortable with Nicolae Miu snorkeling over in the direction of the young men because he was afraid he might be perceived as a pedophile. Eric Von William would not have engaged in that conduct. Is that conduct unlawful? Is it a criminal offense? Does it strip you of self-defense? No. But it's much like the situation with George Zimmerman, right? So George Zimmerman, Trayvon Martin, about a decade ago down in Florida. George Zimmerman perceives Trayvon Martin, who he doesn't recognize, from his community. And this was a condo complex in Florida that had been the subject of a tsunami of burglaries, home invasions, property thefts, so bad that they finally set up a neighborhood watch. They were trained by the police, the neighborhood watch people. George Zimmerman volunteered for the neighborhood watch, got this training from the local police. And the training said, if you see someone suspicious in your community, call the non-emergency number and we'll send out a patrol car. And George Zimmerman's in his car driving back into this condo complex. He'd gone food shopping. It's raining. It's dark. And he sees a dude walking around aimlessly, looking in the windows of people's condos. And George Zimmerman says, that looks suspicious to me. I'm going to call the non-emergency number like I was trained. And he does that. And he gets a dispatcher on the call. And the dispatcher asks him questions, what's going on? And Zimmerman describes it. And he's describing Trayvon Martin. Trayvon Martin sees Zimmerman sitting in his car on the phone. And Trayvon Martin realizes, well, he's probably talking to the cops. So Trayvon Martin actually approaches Zimmerman's car, circles it. George Zimmerman's describing all this to the dispatcher on the 911 call, so we can hear it. And then Trayvon Martin decides to run. And he runs around the corner of one of the condo buildings. And George Zimmerman on the phone says, he's running. And the dispatcher says, where's he running to? Well, George Zimmerman can't see through a building. So George Zimmerman, to answer the dispatcher's question, gets out of his car, walks over to the corner of the building, looks around the corner to identify where Trayvon Martin may have run to. And at that moment, the dispatcher can hear wind noise over the cell phone, says, are you following him? And George Zimmerman goes, yeah. And the dispatcher says, we don't need you to do that. And George Zimmerman says, okay. And he hangs up with the dispatcher after the dispatcher assures him a patrol car is on the way. George Zimmerman starts walking back towards his car, and Trayvon Martin comes out of ambush. He'd hidden behind a bush. He was observing George Zimmerman. The moment George Zimmerman hung up the phone, Trayvon Martin came out and attacked him. George Zimmerman made zero legal mistakes. Zero. That was as clean a case of deadly force self-defense as I've ever seen taken a trial. But did he make a tactical mistake? Did he make a mistake of preclusion? And I think if you ask George today, and I didn't know George at the time, but I've come to know George since, if you were to ask George today, he would say, yeah, I made a tactical mistake. I put myself in an ambush position and I got ambushed. Now, that doesn't lose you self-defense, but it gets you in the fight. And once you're in the fight, you have a greater than zero risk of death and a greater than zero risk of getting convicted. Fortunately, George Zimmerman did not get convicted, as he shouldn't have been convicted. Could Nicolae Miu have precluded his confrontation with these people? Maybe, right? I mean, Eric Von William would say, well, I wouldn't have gone over there because everyone's drunk. They're young kids. They tend to cause trouble. I'm staying away from drunk, strange people on the river, especially young men. Is Nicolae Miu required? Is it like a legal requirement, a legal duty of him to recognize that this theoretical risk exists? No. But is it more prudent to have that foresight and apply it? Nicolae Miu would not be going to prison for the rest of his life had he done that. It's not a crime. He didn't do anything legally wrong. But I would suggest it was an error in judgment that we can learn from. All of us can learn from. Let's see. Let me go back here. It scrolled on me. Yeah, lots of comments. It's actually filling the queue and rolling over, folks. So I'm not going to see everybody's. Sorry about that. Will Parker, my good buddy Will Parker up in Montana, teaches self-defense, good shooter, graduate of the Law of Self-Defense Instructor Program, very smart guy, knows this stuff very well, says feelings, they can F you over. Yep. Of course, now he's been convicted of hurting children, so see how that goes for him in prison. Jeffrey says he should have been a platinum member. Well, yes and no. I mean, I think the defense did a good job here. There's stuff they couldn't really do anything about, like his lying to police, right? That kind of consciousness of guilt evidence, or the emotional nature of the events. I don't think that the defense made any grave errors here. What would have I advised the defense to do differently? Not much, I have to be honest. But if he had been a platinum member, one of the consequences of that, so the reason platinum membership comes up, folks, is my legal practice is a consulting practice. So I provide legal consults to other attorneys. All my clients are other attorneys who are lead counsel, like these defense counsel were for Nicolae Miu, lead counsel for their own clients. And I provide legal consults to those cases. But I only provide legal consults to people who are platinum members of Law of Self-Defense. That's our higher level of membership. And so for those members, we used to take outside consults from anybody who could pay our retainer. Our retainer was very expensive. It was a $10,000 minimum retainer for me to consult on a case. We don't take outside consults anymore. We only do them for platinum members. And for our platinum members, they get the consult for free. Would that have helped this case? I don't know. I'll be honest. I'm not sure. I mean, I'd like to think it would add some value, but it's not like this defense was by no means a train wreck. But one thing platinum members also do tend to get as well is a lot of education and training. So, for example, this offer that I've put up here gets people 5 years of platinum coverage. So for 5 years, if you're involved in a use of force event, you get my legal consult on your case for free. No charge. for free for your trial, for an appeal, for a retrial, all of it, until every legal avenue is exhausted. And you get $2,000 every course, every book that we have to offer in every form, DVD, online streamed, everything. You get all that, 5 years of platinum coverage, thousands of dollars of educational content for 82 cents a day. We try to make it as inexpensive as possible, folks, 82 cents a day. So what would have helped Nicolae Miu in this particular case may not have been so much the platinum consult itself, but all those educational materials and training. Again, as I mentioned when I talked about our upcoming full day, Saturday, April 20th class, if he'd taken that class, he wouldn't be in this situation. If he'd had the benefit of all of this, he wouldn't be looking at a life sentence, assuming he, of course, he followed what we teach. Let's see. Sean says, I really like this judge until the hearing on the jury instructions. Yeah, me too. Me too. I thought the trial actually went very well for the defense and very poorly for the state. I thought the prosecutors were terrible in terms of lawyers on this case. I just didn't think they were proficient at the skill sets needed to be a good lawyer from the beginning to the end, really. But then when it got to the jury instruction conference, every ruling by the judge was in favor of the state and against the defense. Let's see. It may have been because of what he said in the car when he's in the patrol car handcuffed and he's pretending he doesn't know what happened. Again, that shouldn't intellectually change anything here because we have the video, but emotionally it can. If Nicolae Miu had simply gotten out of the river on the bridge, seen the first cop, and walked over and said, I was involved, I defended myself, I'm asserting my right to counsel and asserting my right to silence, he would have been in an infinitely superior position than here. Let's see. I do hear Wisconsin is liberal. I've only ever ridden a motorcycle through it. Let's see. Cycle Boy says, I bet they went with him having the knife open early. Maybe, but I mean, that's about as inoffensive a step as one could imagine because he didn't brandish it. I mean, apparently no one saw the knife. So he was prepared to defend himself, but he wasn't actually using it or threatening to use it. By the way, does this suggest that it might be helpful to not have to do that, to be proficient at getting your knife out of your pocket, and if it's a folding knife, to get it open at the last possible instant, consistent with self-defense? Or maybe to have a fixed blade knife you don't have to open? I mean, the truth is, for actual self-defense purposes, if you're going to use a knife, folding knives are, the fact that you have to open it is a distinct disadvantage compared to a fixed blade knife. On the other hand, carrying folding knives is pretty common, and carrying fixed blade knives is a lot less common, so it can be made to look odd to a jury. Will F says, I believe the primary cause of the conviction was the blatant and deliberate misrepresentations of law and evidence by the prosecutor, including trying to convince the jury that actions minutes apart were 2 to 3 seconds apart and in the wrong order. Yeah, but that's the defense has to address that. I mean, prosecutors do that. Let's see. Zach says, this case is a quintessential advertisement for your classes and book. If only he had known the law and how to respond after defending himself. Would have made all the difference. Yes, this actually, someone mentions the, I'm not sure that's the right name. Marshall, right? So when I mentioned a knife instructor who teaches more precise cuts than like a broad disemboweling move, I was speaking of what someone's mentioning right now. Will Parker is mentioning Marshall. It's not like the sheriff, though. It's Marshall, like Martial, like battle. Martial blade concepts. That's run by Mike Janich. I know Mike Janich. He and I used to be on a TV show together. It was a TV show called The Best Defense on the Outdoor Channel. And Mike Janich's expertise, he lives right here in Colorado. I think he works for Spyderco, the knife company, or at least he did. I don't know if he still does. I haven't really talked to him since the TV show ended. But a very nice guy and very skilled with a knife. Been teaching it a long time, very proficient, studied a lot of different arts. And his preferred technique are these more precise, smaller cuts targeting specific functional parts of the body. So they are utterly debilitating, but you're not, cutting someone's neck or disemboweling somebody open. Duncan says the fact that he lied about the preceding and proceeding events got him, absent the fact that he talked with police at all. Maybe the visceral nature of the wounds was a few extra pounds on the scale. Yeah, I think it might be, right? That kid laying in the water with his guts out, floating around. That's a tough look. Knives are nasty. Knives are nasty. This was a little pocket knife, very similar to the pocket knife I carry. And just, one's disemboweled. Riley Madison had internal organs coming out of her stab wound in her body. One only had a couple inches, but one was fatally stabbed in the heart. One only had a couple stitches, I should say. Let's see. It says Miu lived in Minnesota. Okay, fine. I guess he was tubing in Wisconsin, I suppose. I got to be honest. To me, I kind of conflate the two. No offense. Lance says, don't go to stupid places. Don't hang out with stupid people. Don't do stupid things. Yeah, I was taught that by, I forget now. It's either my dad or John Farnham, the firearms instructor here on the Front Range here in Colorado, up by Fort Collins. By the way, John Farnham's a fantastic firearms instructor and an old, incorrigible dude. I think he was in Vietnam, but a great instructor. His wife, Vicky, teaches with him, also a great instructor. If you have an opportunity to take a class with John Farnham, I would strongly encourage you to do that. Farnam. I don't think there's an H in there. I always forget. Let's see. What happened? It auto-filled. Oh, there he is. Yeah. Okay. I didn't find his homepage. But it's Farnam, John Farnham. Defensive Training International is his company. So great stuff. John does great work. I strongly recommend it. I imagine Will's probably taken a course with him too. I don't know. All right, let me get back to the Q&A. What do I do at my Q&A window? There we are. Lawful to Shoot says, it seems the jury believes he acted recklessly on young people, just having fun, boys being boys, and that it was not a deadly force act, but instead just rough treatment, which is commonplace in a drunk partying group. Could be. They just didn't see a deadly force attack, the jury. That's possible, in which case the knife would not be perceived as justified deadly defensive force. So imagine if the first statements by Nicolae Miu to the police with a lawyer present had been, I thought I was going to be drowned, instead of had nothing to do with me, or I only heard about it, or they attacked me with a knife and I took the knife away from them. Different case? I think so. Also a good reminder that, the jury pool, your jurors are not necessarily like you. Your juror pool at best reflects whoever lives in your community. You could be the most politically conservative, gun-friendly dude in the world, but if you live in Massachusetts, at least the eastern half of the state, where all the people live, there you go. Not Cupcakes asks, do you have any plans on covering the Karen Reed trial next week? She's accused of hitting a Boston cop with a car and leaving him to die in a snowbank. I haven't really looked at it. Is she claiming self-defense? Or is she claiming she just didn't know she hit him? These trials take a lot out of me, folks. So if they're not a self-defense trial, I tend not to do them. Yeah, Philip says, given that Quentin Carlson, the elder of the Carlson group, the G2 in that little illustration with the dots, testified his group stopped tubing on the Namakagon River, and this happened on the Apple River, I imagine what goes on tubing on the Pine River. Just, yeah. Right. Will F says, the judge tipped his hand that he wanted a conviction when he locked in those unjust jury instructions. Yeah, so most, state trial judges are elected. So someone had asked earlier, I can't remember where I saw it, would he have been better off going for a bench trial? You never know. You don't know what the biases of the judge are. The judge is elected. Does he like his job? Does he want to get reelected? Are the politics of the event and the community such that if he were to acquit, that he'd be out of a job? Does that influence his decision-making on a bench trial? Let's see. Up. Jeffrey asks, can they appeal on jury instructions? It's very difficult to appeal on jury instructions that follow the standardized instructions. You get in trouble on jury instructions, the trial judge does, when he modifies the instructions. Here, the judge was very conservative and basically turned down every defense request for a modification. That left a lot of ambiguity in the instructions. They're not drafted how I would draft them. But often, like if you talk to attorney Steve Gosney, Public Defender's Office, Appellate Division down in Florida, good friend of mine, good friend of the show, he'll tell you that as a public defender, he's tried to contribute to these jury instruction committees, and they don't want to hear from him. These committees are dominated by the judges, who are often former prosecutors, and by prosecutors. So you end up with jury instructions that are much more favorable to the prosecution than the defense. Even though they accurately reflect the law, the tone and how they're structured and the sequence of things has a big impact on how they're interpreted, especially by a lay audience like a jury. Jason says the families of these 6 football player kids from a community of 15,000 would have many connections and influence with that community. Yeah, for sure. So the issue with the jury instructions was, for example, if the jury instruction says if the defendant provoked the confrontation, he loses self-defense. I'm going to paraphrase here for purposes of simplicity. And the defense wanted added in there, but or in addition, the state has to prove that provocation by the defendant beyond a reasonable doubt. And the judge said, no, I'm not going to add that. Because 8 pages later, there's a general statement that says the burden's entirely on the state to prove guilt beyond a reasonable doubt. Was that true? What the judge was saying? Yes. Is that an accurate representation of the law by the jury instructions? Yes. If you're a judge and you know that's coming 5 pages later, does that adequately inform a judge who has the burden and to what degree? Yes. If you're a lay audience, is there any harm to adding the burden of proof everywhere it's relevant in the jury instructions to reinforce that that is, in fact, the legal standard? That's what I would want as defense counsel and as a defendant. But the judge is not required to do that. It's not in the standard jury instructions everywhere, because the standard jury instructions contemplate that you'll include the chunks of jury instructions that are needed for a particular case. And that's what the judge did here. So I don't think there's any real prospect of getting a reversal based on using the standard jury instructions. That's just not a thing. Yeah, staying away from groups of drunk people is generally a good idea. And I like a drink as much as the next guy, but you don't see me hanging out with a bunch of drunk people, especially if they're strangers. Yeah, so I went to one of these all-inclusive Mexican Riviera joints a couple years ago, 2, 3, 4 years ago, and yeah, I almost had to stab some dude in a swimming pool. Thankfully, I didn't, but it could have come close. You know, he decided to walk away, which is perfect, exactly what I wanted. I would have walked away myself, except I was holding a 5-year-old in my arms in a swimming pool. Would have been a little bit difficult. This guy was steroid inflated to the 10th degree. But I tell you one thing I decided, I'm never going back to one of those places again. No, certainly not a budget one. We had gone with a whole bunch of neighbor people and they picked it out. And I was, nope. All inclusive means there's a lot of people drinking a lot and people start making poor judgments. Zach says, it's also apparent the defendant did not mentally and physically prepare himself for lawful self-defense. Yeah, I think he had acted reflexively, which means not really in an informed way. Chuck says, we do not have a justice system, we have a legal system. That's correct. So when you consider the criminal justice system, the first thing to keep in mind, the most operative word in the phrase criminal justice system is criminals. It's a system that's optimized for dealing with actual criminals. So if you're a good guy fed into that system, it's a really unpleasant and dangerous experience. The next most operative word in criminal justice system is system. It is a bureaucratic system for the administration of justice, which doesn't mean justice like fairness. It just means ideally due process application of these rules that society creates. Doesn't mean there's anything fair about it. Is it fair this defendant had $1 million bail? I mean, what if he'd been acquitted? He would have spent, 21 months in prison, in jail, with $1 million bail? You don't get that time back. Elman says, this also reinforces my decision to purchase a dash cam with front read inside cameras. I'm not sure what that means, but again, video helps you if the video helps you, right? If the video is good, you did the right things and it's caught on video, it's helpful. Of course, it could be ignored even then, right? I mean, I would have thought the video here would have led to acquittals, but it didn't. Philip says, Steve Tarani, another well-known self-defense trainer, calls the concept prefence. I said preclusion, prefence, like defense, but prefence, and teaches an entire course on it. Yep, it's just smart. It's having foresight, basically, is what it is. Elman asks, any recommendation for what dash cam they get? If that's directed to me, I don't have a recommendation. I don't have any familiarity with dash cams, but any other law self-defense member should feel free to put one in. Not Cupcakes asked, did you cover the Amber Geiger case? Yeah, I did. This was the shooting in Dallas, right? Of Botham Jean. Am I thinking of the right case? Yeah, the Botham Jean case where she went into the wrong apartment. Yeah, I covered it. I thought that should have been an acquittal in that case as well. But it was a closer call. I mean, very telling to me was that so this was the case where Amber Geiger, a Dallas police officer, gets off, I think it might have been a double shift, tired, goes to her apartment complex, opens the door to her apartment complex, except it's the wrong apartment. A black gentleman, Amber Geiger is white, a black gentleman named Botham Jean is in his apartment. I think he was eating ice cream. He certainly wasn't doing anything wrong. He hears the door open behind him. He stands up, he turns around, and Amber Geiger shoots him because she thinks she's in her apartment and there's an intruder in her apartment. She's just in the wrong apartment. So obviously she made a mistake, right? A mistake of fact. But of course, you're not required to make perfect decisions in self-defense. You're required to make reasonable decisions. So you could decide that was a reasonable mistake of fact. And you may be thinking, well, how reasonable can it be to walk into the wrong apartment? Well, first of all, if you're fatigued, and if you've ever lived in one of these apartment complexes, a lot of them can look quite the same. In fact, the defense did a survey of the people living in the apartment complex, and something like in excess of 30% of them had either had strangers unintentionally walk into their apartment or had themselves unintentionally walked into the wrong apartment. So it was not an uncommon occurrence. Certainly, I don't believe there was any malice on Amber Geiger's part. She didn't know Botham Jean. She had no reason to just want to kill him. So I thought, and again, given that the burden on the state is to disprove self-defense beyond a reasonable doubt, given that heavy burden, I thought there was a path to acquittal for Amber Geiger. She was not acquitted. And part of the dynamic, of course, is she was white, he was black, so it became racially energized. And she's a cop, which makes it even worse from that respect, and so forth. Yeah, when the judge went for the state argument about the adding those last lesser includeds at the end, the recklessness charges, I don't see recklessness here, because recklessness would be an unintentional cause of harm, an unintentional stabbing, and this defendant stabbed everybody intentionally. But the way many states and Wisconsin describes that is utter disregard for human life. And how that normally applies would be the drunk driving scenario, where you're not intending to run somebody over and kill them, but you're creating an unjustified risk of death or serious bodily injury. And you know you're doing that, and you're intentionally ignoring the risk. And then death results. So you go to a bar, you get drunk, you get behind the wheel of a car. You're not intending to run anyone over and kill them. You're just intending to drive home. But you know, when you get drunk behind the wheel, you're creating an unjustified risk of death to some innocent person. And then you run over somebody in the crosswalk and you kill them. That's a reckless killing, recklessness. Unintentional. If it was intentional, it would just be murder, right? So it's unintentional. And often that's described as utter disregard for human life, which would cover the drunk driving scenario I just described. But the judge applied that in a much broader context. The judge said, well, they could say that a jury could believe that the way the defendant didn't try to provide aid, that he just floated down the river and left the care of those people he stabbed to other people, a jury could see that as utter disregard for human life. And I think that's quite a stretch. But I think that really exposed the judge's his own true perception of these events. I cautioned from the beginning, if this defendant gets convicted, he's going to get the max on everything. And I certainly believe that to be the true now. And if this had been a bench trial, given those comments by the judge at the jury conference, the jury instruction conference, yeah, I absolutely believe as a bench trial, he would have convicted for sure. The Amber Geiger case, I've got thousands of blog posts and videos on our member law self-defense member blog. It's in there someplace. There's a search function, I think, on our website. I don't remember if I live streamed the trial, actually, or if it was televised, if I just had to cover it by news reports. I just don't recall. I cover so many of these trials, folks. Kyle said, I was surprised there wasn't more expert testimony. Maybe he didn't have the means. A use of force expert might have been helpful. On the other hand, it would have been most helpful if he'd been able to sneak in kind of ultimate findings of fact, like any reasonable person would have been in fear of death under these circumstances. Often judges won't allow that. You tend to get away more with that, actually, when it's a police officer defendant. No good reason for that, but that's been my experience. And if you're not gonna, if you know the judge isn't going to allow your expert witness to go to a final finding of fact, which he shouldn't, that's up to the jury. But as a defense, you'd love to sneak that in. how's he really helping you? I mean, we all know knives are dangerous. We all know what drowning is. We all know what disparity of numbers is. We all know the defendant had a quadruple bypass. We could see what he looks like. We could see what the young men look like. Let's see. Jeffrey says, question, can you make the replay of your day-long course available to us Platinum members? Usually the Platinum members already have our advanced course in DVD form. What you might want to consider, I mean, we make different offers for Platinum membership all the time. You might want to consider what we have on the screen here. If this deal includes a ticket to the April 20th class, the live class, or the next one if you prefer the one in October, but it includes a ticket for you. Yeah, it includes a ticket to. Yes, it includes a ticket to the April. In fact, I think it includes a ticket for you and your significant other, if I remember correctly. And it includes that full day course in DVD form. A 4 DVD set is one of these courses that's included there. So if you're already a Platinum member and you're paying whatever you're paying, $50 a month, I'll make it up. You may want to switch over to this. This may be more advantageous for you, assuming you intend to stay a Platinum member for 5 years. And then you get all the courses and a ticket to the live class. I would recommend that, actually. And this is available you can learn more about this offer it's right there on the screen, lawofselfdefense.com/82 cents. 82, numbers 82, and then 82 cents. Kyle says, I wonder if Nicolae Miu would even have gone to trial if he'd applied what he learned being a Platinum member. No, I don't think he would have. Because when we teach our courses, we illustrate them with real trials. Like I'll be incorporating the Nicolae Miu defense into Saturday, April 20th class. I'll be talking about it then as cautionary tales for what the law of self-defense community members need to be aware of, how things can go sideways. Let's see. I'm not going to repeat similar comments. There's just too many of them here. Taylor says, what's the reading level required to understand jury instructions? How far above average are they? Yeah, it's a problem, right? So we looked at jury instructions, right? I would say that's high school, like old school, like when I went to high school level reading level there. It's a much higher level of reading than I use in my own book, Law of Self-Defense Principles. The hardest part of me writing this book, folks, was to not write it like jury instructions, to not write it like a lawyer would default to writing it. My editor, God bless her soul, my editor sent this book back to me at least a dozen times for rewrites, to the point where, I hate to say this, I was like, she says, you gotta make it simpler. You got to make it plainer. You have to make it less technical. And after the 8th or 10th time, I was like, how effing stupid can people be? I can't make it any simpler. But she was right and I was wrong, and I could make it simpler. And in fact, the biggest compliment we get on this book is that it's easy to read. It's easy for a non-technical audience to understand in a practical, actionable way. So that editor was very frustrating. In my experience, the hardest part of writing a book is not writing the book. It's the editing process afterwards. She was very frustrating. I was unhappy with her at the time. We had words. I feel bad about it. I've apologized since, but she was 100% right. So yeah, these jury instructions are written at a substantially higher level. So what's the actual reading level of many people who might be on a jury? 6th grade, 8th grade? This is a higher reading level than that. Kyle says, I was very close to the Amber Geiger case. She had a conviction coming, but not murder. I've also answered those apartments. It's not that hard to tell a difference unless you've worked way past your level of functioning. Also precluded by rules for the PD and fire rules. I'm not sure what that means, but yeah, I mean, I would have been amenable I'm not horrified by the Amber Geiger conviction. I can see how a rational person can get there. I'm just given the burden on the state. I could also see a clearer path to an acquittal. If there had not been the racial politics, it's hard to say. It's hard to say. It was a closer call than this case, for sure. Philip says district attorneys as elected officials are inherently political animals. Yes. Yep. And how do you do away with that? At the federal level, of course, they're appointed. How does that help? They're still politically motivated. They're appointed by politicians. Okay, is that all the law self-defense member questions? Then I'll take a look at the super chats. Needs to be a $10 super chat, folks, if you're on YouTube. Oh, let's see. I had a poll. Let's see what we got. Nicolae Miu found guilty on all charges. Was this a just verdict, an unjust verdict, or an insanely unjust verdict? On the YouTube poll, insanely unjust verdict has a plurality, 44%. Unjust verdict, 38%. So that's 82% some form of unjust verdict. Only 18% think it was a just verdict. And I'll end the poll there. 2,500 votes. Very much in line with what we were getting on predictions for outcome based on law and evidence. Let's see. Bup. All right, so let me take a look at the super chats. And if you're on YouTube, give me a subscribe. Why not? They're free. Hit that like, thumbs up button. We probably don't have nearly enough of those. How many likes? Well, that can't be right. I'm going to refresh the page. 1,400 people watching, 820 likes. We can do better than that. Come on, folks. 1,400 of you. We should have at least 1,400 likes. Over 1,000 for sure. I mean, if you're spending your time here, surely you must like something about the content. If it's not the intro song, maybe it's something more substantive. Holy cow. Okay, a whole bunch of super chats. So let me do this. Let's see, how do I do that? See all from today. Someone paid $2 to tell me I was muted earlier. That's really kind of you. Thank you. Andrew Starr. He had done a super chat earlier in the week too. Thank you, Andrew Starr. Very kind. All right, April 11th. Fish, $10. Thank you very much. I'm going to slide this over so I'm looking into the camera. In the event of a hung jury mistrial without prejudice, there's never prejudice with a hung jury. So you can always retry again. Can testimony prejudice would be if a judge dismissed a case with prejudice, it means it's dismissed and you can't bring it, the state can't bring it back. Very rare for that to happen. Very rare for a dismissal under any circumstances. But dismissal with prejudice is almost unheard of. It's theoretically possible, but it would take some really egregious misconduct by the state. But if a jury just can't agree and you have a mistrial for that reason, then there's no prejudice. The state's always free to try again. Double jeopardy hasn't attached yet. Can testimony from the previous jury be admitted as evidence in the new trial, or would all the witnesses need to be brought back to retestify? I think you mean can testimony from the previous trial be admitted? Yeah, it can be admitted. Now, normally you would call the witnesses back because for the new trial with a new jury, because you'd get a new jury, you'd want them to hear the witnesses in person too. But to the extent that a witness may say something different on the witness stand in the second trial than they said in the first trial, you could use the transcript, the testimony from the first trial to impeach them. And if a witness were to become unavailable, say a witness were to die before the second trial, you could get their first trial testimony read into the record from the transcript. So it would be admissible. John Lineman, $10. Thank you. Says, if it's a hung jury, do you think the prosecution would offer Miu a plea bargain? Nope. I think they were always going for the whole thing. Martin gave two $5 super chats back to back. So I'll count that as $10. Is retreat a requirement? It's not a legal duty in Wisconsin. But the jury is allowed to consider whether your failure to retreat undermines the reasonableness of your use of force. And also, what if Nick would have been a peace officer? Do they get special privileges? Not in the black letter of the law, but they so this is a river case, but they kind of swim in different waters. So, for example, as a non-law enforcement officer, I'm never privileged to be the initial aggressor in a confrontation. Police are. Police are often the initial aggressors. If they have to compel compliance with lawful arrest, they'll use force, right? The first person to use force. They're the initial aggressor. The difference is, for me, that would be an unlawful use of force. For a police officer making a lawful arrest, that's a lawful use of force. So it's more accurate to say you can't have been the unlawful initial aggressor. But usually I'm talking about non-police officers in these cases. So the police officer might have said, for example, well, I saw there was underage drinking. That's why I didn't retreat, because I was going to make an arrest or issue a citation or whatever. So he had a lawful reason, to rationale for staying that made his staying reasonable, that Nicolae Miu would not have. Robbie McCann, again, I'm going to combine a couple of her under $10 super chats here. Until we have been in that situation, none of us know how we will react. You can drown with your head never going underwater. Look up dry drowning. Yeah, I believe that's all true. But first of all, prepare. If you prepare, I mean, those of us who watched this trial and saw this outcome and heard me talk about it, are you more prepared if you find yourself in a similar situation? This is 80% of what I do is education. Essentially educating the law self-defense community about how these things actually happen and how they go down and what the outcomes are like, so that you're training yourself based on the mistakes and outcomes of other people. Just like pilots train themselves about airline crashes without having to experience an airline crash, right? They read the crash reports of other pilots. Andrew Starr says, I think white Karens are incapable of going against minorities even when they are in the wrong. Jawan should be in jail. Yeah, Jawan, a different prosecutor could have argued that Jawan incited this fight, incited this violence. Christina says, Andrew, could he have chosen a bench trial, and do you think the result would have been different? I don't know if he could have or not. The states vary on this. There are some states in which the defendant can demand a jury trial, and the state has nothing to say about it. So if the defense demands sorry, it's been a long week. There are states in which the defense can demand a bench trial, a trial without a jury, where the judge plays the role they always play as the finder of law, but also assumes the jury's role as the finder of fact. There's no jury. The judge is making findings of fact. There are a few states that allow the defense to demand that, and the defense demands that the state has nothing to say about it. Maryland is an example of such a state. Most states don't. Most states, you can only get a bench trial if the state agrees. The thinking is that the defense has a right to a jury, hear their narrative of innocence, and the state has a right to a jury to hear its narrative of guilt. So either one of them can demand a jury, and that's what will happen then. If he had demanded a bench trial, if you'd asked me through 98% of this trial, might a bench trial have helped him, I would have said yes, until the jury instruction conference. And I heard the judge's rulings and rationale. And now, having heard that, I'm utterly convinced if it had been a bench trial, he would have been convicted 100% by the judge. Nicholas Brown, $10. Thank you very much, Nicholas. Says, the knife was out before physical conduct. I think that played a role. It might have. Even though he wasn't using it in a threatening way, even though I believe that if he had brandished it, he would have been charged with criminal brandishing. That may have played a role. I'm a big advocate, for example, in gun self-defense, of not getting your gun out until the last moment consistent with safety. I'm not a big fan of defensive displays of guns. Just not. Because the moment you're presenting force, especially deadly force, for the purpose of changing someone else's behavior, which is what you do if you take your gun out of the holster, have it at low ready, stay back, I'm prepared to defend myself. You're threatening someone with imminent deadly force to change their behavior. Well, that also meets the conditions of assault with a deadly weapon, aggravated assault with a deadly weapon, which is good in many states for 20 years in prison. Now, what you would do is justify that as self-defense. But what if they don't buy your self-defense argument? Then you're doing 20 years in prison. So I'm not a fan of incurring that kind of legal risk unless you have to. Now, part of what makes it have to is, the more proficient you are with your ability to deploy whatever your defensive tool is, the greater your luxury of being patient and waiting until later. And then maybe you won't need to take your gun out or knife out. I've carried a gun and knife every day of my adult life. I mean, a knife since I was a kid. I've never come close to having to take them out for defensive purposes. Not once. In 33 years carrying a gun every day? Carrying a knife for probably 50 years? Close to it. I am, however, I consider myself extremely proficient in bringing a pistol into play from my person if I need to do that. Probably less so with the knife, but my primary deadly force tool is my pistol, not my knife. My knife is a backup for my purposes. Let's see. Andrew Starr, again, when faced with minorities, you have no right to self-defense against white men, especially when white women are involved. I don't know how much a role that played here. I haven't watched the local medias, but that could have been a role. There's it's extremely common in America today for cases that can be racially energized to become racially energized. Bryce says you should have listened to the local news reports, extremely biased. I believe you. That would be my expectation, but I'm not in Wisconsin, so I don't have access to those reports. Abo Suleiman, SAR 10. I don't know what the currency SAR is. What is that? Is that Saudi Riyal? Really? Saudi money? What am I going to do with Saudi money? I'm just kidding. It's much appreciated. What's that transfer? What is that in dollars? Oh, it's only $5. Is it? It's only $3. You fooled me with the 10 integer. All right. Self-defense is now a crime, he says. Yeah, well, not quite, but it's not a lock. It's never a lock. The risk of conviction is never zero. Jim Satala says $20. I just rewatched the verdict. It's all the reckless charges that were added after the defense rested. Seems like a point for appeal. They were not given their opportunity to answer the charges. It was after they rested, but before they closed. And you're allowed to. So the way the law works is the defense is presumed to be on notice that lesser includeds could be given to the jury. That's the way that works. You're not allowed to be surprised. If the facts could support the lesser included, you're presumed to know the lesser includeds could be presented to the jury. John Lineman says, what do you think hurt him more, talking to the police without an attorney or taking the stand? Talking to the police without an attorney, and what he said when he talked to the police. I think he had to take the stand. Please take a look at the Andrew Raymond case. The unreleased footage and facts are unbelievable. I don't think I ever heard of that one. Is it recent? Andrew Raymond. Is it a self-defense case? Is that the Andy Raymond? Let's see. From a couple years ago. A gun shop owner shot at a police officer who was working in an undercover vehicle. Arrested and charged with first-degree assault, use of a firearm in a violent crime. It seems like he thought he was going to be the victim of a burglary. Well, maybe when's he go to trial? If I've missed the trial, I probably won't go back to cover it. It's I'm too busy already. But if they're gonna broadcast the trial, then I may take a look at it. I got another $3 in Arab money. The jury of the internet ruled not guilty 100%. Yeah, I would have voted for not guilty were I on this jury. Nick Brown, $10. Thank you very much. Says, I could see the motivation for Nick to lie when there are a dozen witnesses likely to lie in the other direction after having, as a mob, taunted and assaulted him for no good reason. Yeah. I mean, of course, he didn't know there was a video, right? He may have thought he could walk away from this. And of course, there's always an incentive to try to disconnect yourself from the event because there's never a 0% chance of conviction. You could have done everything perfectly lawfully and still get convicted. So I understand the incentive for people to avoid that risk if they can. The trouble is, if you try to avoid it and you get caught, it looks really bad. It's consciousness of guilt evidence. And then, yeah, so I'm sure when he's telling that story to Brandy Hart, investigator Brandy Hart, he doesn't know there's a video. It shouldn't have mattered. I think the video substantiates self-defense here, but the lying doesn't help. Especially in terms of propaganda, right? So propaganda, by definition, is not fair reporting or coverage. If the news media is simply repeating 10,000 times, he stabbed a bunch of people and then lied about it afterwards, that sounds horrible, right? And maybe that's exactly what they did. So more 25 Arabic dollars. Welcome to Wisconsin, a place where you can't self-defend. I've never been to Saudi Arabia, by the way. Maybe I should do a remote show there. John Linehan, $10. People need to know that when a police officer shoots someone, they're not allowed to give a statement without their attorney being present. The police officer is not. It's a little more complicated than that. Sometimes police officers can be more, we want to encourage police officers to give a statement early. But if they give a statement under those circumstances, then generally the statement can't be used against them in court. So that's a provision that exists for police officers that doesn't exist for civilians. So if a cop's bosses come up to him and say, hey, you shot that guy, I want you to tell me why you did that, and he gives a statement, generally that statement cannot be used against him in court. And that's just to, most police shootings of suspects are lawful. So we don't want that to be an open bleeding wound in the community for 2 years. The cop's not willing to say a word because he's concerned about self-incrimination. We don't want that to be an open wound in the community for 2 years until there's a trial, if we can resolve it immediately by hearing from the cop what happened. All right, a couple more. Rob says, will you look at the Daniel Penny subway chokehold case? An emotionally disturbed man was attacked. Yeah, I've covered Daniel Penny. I mean, the news reporting of the event. I've done a bunch of articles on it for the Law of Self-Defense membership, at least. Videos, podcasts. Chokehold cases are tough, especially in the current environment. Let me switch this over to something useful. There we go. Here's the problem with chokehold. So I study jiu-jitsu, Brazilian jiu-jitsu. I'm a student. So I use chokeholds all the time. I'm choked all the time. And if you do a chokehold properly, there's really zero risk of serious harm. Don't hold it past 6 seconds. I mean, in the gym, people just tap out. So, but if you were to use it in self-defense appropriately, the expectation would be you put the choke on, 6 seconds later, the person's unconscious, you let him go, the fight's over. The real world's more complicated, though, and I see a lot of cases get jammed up on this. I did a legal consult for a chokehold homicide case here in Colorado. Two homeless guys got into a fight, and one of them had very little bit of jujitsu training, and he was attacked by a much larger homeless guy. And the smaller defender did a cross-collar choke on the homeless guy, on the larger aggressor. And the larger aggressor died. He just died. Now, the state argued that he died because you strangled him, right? You kept the choke on until he was dead. There was really no evidence of how long the choke was held, but the state said, well, he's dead from the chokehold. That doesn't happen from a 6-second chokehold. So we know from the death that you held it longer. And that's strangulation. That's murder. The trouble with chokeholds in the real world is that in the real world, we're not dealing with healthy BJJ students in the gym or healthy police cadets in the academy. We're dealing often with mentally unstable, physiologically frail people in real life. And frankly, a lot of those people, you put a chokehold on them and they just turn off like a light switch. This case I consulted on, the guy who died was a lifelong alcoholic, had tremendous existing heart disease, respiratory disease, very frail physiologically, blood alcohol level of, you're not going to believe this when I tell you, especially those of you who may be cops or, know something about blood alcohol levels. You may be less surprised, but even you'll concede this is a ridiculous number. 0.458. 0.458 blood alcohol level at autopsy. That's a lot of alcohol in the blood system. So you take someone like that, lifelong alcoholic, 0.458, energized because he's attacking someone, heart disease, respiratory disease. You put a choke on him for 6 seconds. That guy just died. He just died because his own physiology killed him, not because the defender killed him. I'm proud to say we got an acquittal on all the charges in that case, that chokehold case. But it's a real risk with chokes in the real world. If they televise the Daniel Penny case, I'll certainly cover it like I covered this trial. I don't know whether they will or not. New York, generally in a politicized prosecution, the state doesn't want it televised. So, but we'll have to see what happens. If it's not televised, there's not much I can cover because you can't believe the news reports of what's happening in court, right? That's why it's so arduous for me to cover these trials, because when I do cover them substantively, I have to literally watch every minute of testimony and hearings. Samantha Adams, $10. Thank you, Samantha. Says, this is off topic, but did you hear about the Las Vegas attorney that brought a gun to a deposition and killed the 2 witnesses and himself? Was this the family law thing that happened? I have heard about it, but I haven't read about it closely. Listen, there's negative externalities to having guns. Sometimes people take guns and they do bad things with them. That's just the reality of the world we live in. We don't live in a world without guns. Whether guns do good or evil is dependent on the hands holding the gun. And it sounds to me like, listen, family law is, people are destroyed by these family courts all the time. In every sense, financially, emotionally, reputationally. If anything surprises me is that it doesn't happen more often. So, all right, I'll do a refresh of YouTube, Super Chats. Nope, got all those. I'll take another look at, where are the... the member Super Chat. Kyle says the rules for a police officer on a duty to refuse work when not mentally prepared, fatigued, or ill is emphasized in the rules and regs. Now she's the example in both academies on the importance of that rule. Oh, I see. I get it. Yeah, well, that makes sense, right? In other words, fatigue is not an excuse for bad decision making. And I think that's reasonable, given the stakes involved. Let's see. How does invoking citizen's arrest affect one's ability to be the first to effect a force? First of all, citizen's arrest is wildly variable across the 50 states. There's a lot of subjective decision-making in citizen's arrest. You don't have the premature of authority that you would have as a cop with a badge. For all anybody knows, you're a crazy person. The person you're attempting to make a citizen's arrest of also won't know the rules of citizen's arrest. Doesn't know if you're a crazy person. Doesn't know if you're acting within the legal limits and therefore may resist. The resistance may be lawful or not lawful. My advice on citizen's arrest is just don't do it. Don't do it. I mean, that's what happened with the Georgia jogger, right? Ahmaud Arbery. Those the three guys who chased him thought they were making a citizen's arrest. They probably were making citizen's arrest, but the judge in that case left the definition of citizen's arrest sufficiently vague. And of course, that case was so politicized that all those men were found guilty. Let's see. JRS, how did this case differ from the popcorn case? So the popcorn case was Curtis Reeves in Florida, movie theater. Went to the movie theater with his wife, matinee, afternoon matinee. Retired cop, former SWAT cop. Sitting in front of them was another married couple, and the guy of that younger couple was on his cell phone, so the screen's illuminated, was bothering Curtis Reeves. It wasn't the movie yet. It was the coming attractions. But Curtis Reeves asked him to turn his phone off, and the guy basically told him, go screw. I'm calling our babysitter to make sure everything's good at home with the kids. Curtis Reeves was upset. He left the theater, left his wife there, left the theater, went and found the manager, complained to the manager. Manager wasn't going to do anything. Curtis Reeves came back to the theater. The confrontation started again. And then there was testimony that the younger man in front stood up, much younger, larger, stronger than Curtis Reeves, struck Curtis Reeves in the head with something, a cell phone, something, it's unclear, at which point Curtis Reeves pulled his concealed carry pistol, shot the younger man in the chest one time, fatally killing him. And he was tried for murder in Florida. He was acquitted, but there was a lot of close calls there, right? Subjective perception of the threat by the younger man. It could have gone either way. One of the big differences would be the single gunshot, right? Curtis Reeves didn't shoot that guy 25 times, which would be the equivalent of like the disembowelment in this case. Mental image of me in a hijab. That would take a heck of a super chat. Let's see. Kyle says, I've used what I PC call sleeper holds multiple times. Climbed onto a redwood tree of a man to rescue a cop losing the fight. That fall with him landing on top hurt. Oh, okay. Kent says, compare and contrast the high school wrestling headlock versus carotid chokehold versus pressure on the trachea. I didn't wrestle in high school, so I don't know what a high school wrestling headlock is. A carotid chokehold applies pressure to the side of the neck, ideally without pressure on the trachea, the breathing, and it's effectively painless. It only takes a few pounds of pressure on the sides of the neck to limit the flow of carotid blood sufficiently to induce loss of consciousness. It's quick and doesn't take a lot of force. Trachea chokehold is like a bar arm across the front of your throat pushing backwards. That's very painful, very uncomfortable. Could easily crush the trachea. So then the person's never breathing again. You've just killed them, even unintentionally. You're very likely to kill someone with a carotid chokehold. If you're doing it right, after about 6 seconds, they're unconscious, they're limp. If you continue to hold it for a multiple of that, 30 seconds, 40 seconds, you might start inflicting brain damage on them. If you held it for a minute, maybe you'd kill them. But all you need for defense purposes is 6 seconds, 8 seconds, and they're out. They're limp. Probably limp. Sometimes they do go rigid. So you have to be paying attention. But it's really painless if you do it right. How you get there may not be painless. I don't know what you mean by a headlock. I'd have to see it to have an informed opinion. I've never wrestled. I've only done BJ. I don't know if you mean like a guillotine or just an arm wrapped around the neck, like with the person's head in front of you and their body behind you. I mean, there's techniques to get out of a headlock. You know, I would probably do a takedown if I was in a headlock, get back on top of the fight. I might still be in the headlock, but I'd be on top of the fight and not in the position to get my face beat in. But the risk of a headlock is just that you're immobilized and your face is presented for the person's other hand, for the fist. So you don't want to stay there. It's not the arm around the head that's the problem, really. All right. Well, I think that's everything, folks. So I'll just remind everybody, our upcoming Law of Self-Defense. Whoops, that's not what I want. What did I do? Did I lose my... Come on. That's silly, Andrew. Don't do that. Here it is. Our upcoming Law of Self-Defense Advanced class. This is our full-day class taught live by me, streamed to you at your computer using Zoom, taught on Saturday, April 20th. Live class. Plenty of opportunity for Q&A. We only teach this class twice a year, folks. So if you miss this one, it'll be October before you have another chance. Do you know when you'll be attacked and need to have this knowledge and expertise? We teach you about defense of yourself, defense of others, family, neighbors, colleagues, strangers, like an active shooter event. It's all different. Defense of property, different levels of property, highly defensible property like your home, least defensible property. Your pets, believe it or not, are least defensible property. Other people's property, maybe you have a privilege to defend that or not. We teach about consciousness of guilt evidence. We teach about self-defense immunity. We teach about interacting with the police in the aftermath of a use of force event. We teach, of course, the 5 elements of self-defense in a very concrete, real-world illustration way. All that and more, all in a single day. The next one, Saturday, April 20th, in about a week and a half. If you can't make Saturday, April 20th, I would urge you to sign up anyway, because we'll make the playback of that class available to all the registered students for 2 weeks after the live show. So you can watch it at your leisure over that 2-week period. Many people, by the way, take this class more than once. I've had many students take this class 4, 5, 6 times, and they tell me they learn new stuff all the time because it's such a fire hose of information. If you go to lawofselfdefense.com/advanced, we have a list of more than 100 very specific self-defense law questions. Shane is telling me to look for a super chat. I'll do that right after this, Shane. I'll refresh everything and look again. So if you go to lawofselfdefense.com/advanced, you'll see a list of like 100 questions, very specific self-defense law questions we answer in plain English. And we're still in this week is the last week for the early registration period, 50% off the normal registration. It's crazy not to do it, folks. If Nicolae Miu had taken this class and done what I teach, he wouldn't be going to prison for the rest of his life. lawofselfdefense.com/advanced. All right, let me take a look at this super chat. Shane is telling me to look for. I answered it, Shane, earlier. Fish, $10. Thank you very much. In the event of a hung jury mistrial, can testimony from the previous jury, from the previous trial, I think he means, be admitted as evidence in the new trial? Yes. Normally, you would just bring all the witnesses back because that's more compelling testimony. But if a witness were to say something different the second time, you could impeach him with the testimony from the first trial in the form of transcripts. Or if a witness became unavailable for the second trial, like they died or they fled the jurisdiction or whatever, you could use their transcript of their testimony from the first trial. It'll just be read into the second trial in front of the jury. And I think that is everything. Let's see. Charles says, something to remember, people who are choked out with a carotid hold wake up uninjured and often ready to go again. They don't stay out for long. Yeah, they don't stay out for long. That's true. Sometimes when they come to, they're even angrier than before. That's also true. Not necessarily like pure anger, but they're kind of disoriented a little bit because they're coming back to consciousness. You wouldn't want to be nearby. That's your opportunity. That brief period they're unconscious and not fighting is your opportunity to get away. Let's see. Other members from Duncan, Idaho says, I could use some pointers at my questions, comments. Are my questions, comments too long? Am I the wrong type of membership level? Or are they just being missed? I don't think I saw them. No worries if they are. I'm not empirically invested. No, for comments here, I try to answer all the comments. Let's see. Here's one from Duncan. Long term, I feel more verdicts like this contribute to an increased trend of people like Miu saying, well, I guess that's it then. No sense letting myself be taken alive just so I can go to prison until I die. I mean, I don't know what to say about that, Duncan. Yeah, these aren't really, I kind of skipped them because they weren't really legal questions, but I'll read them. I don't distinguish membership level when I'm reading questions in the chat from the members. Duncan sees, how do you see verdict after verdict like this and not see your world growing darker and darker each time? Find your blood pressure and base stress levels rising. How do you maintain such a sunny disposition all the time? Sort of kidding there, but you get my point. Well, I mean, I have the tremendous advantage of not being the defendant. You know, every time I do analysis of these trials, sometimes my conclusions are popular with my community and sometimes they're not. All I can do is my legal analysis. I'm not personally invested in these trials. Nicolae Miu is not a friend of mine. He's not my father. He's not my brother. It's, hold on one second, folks. All right, sorry about that. It was my lunch delivery from my lovely wife, Emily. So Nicolae Miu is not, he's not, I mean, of course, he's a human being. All human beings have value, but not to me on a personal level. It doesn't negatively impact my life if he gets wrongfully convicted. I think this was a wrongful conviction. You know, like if you're a doctor, you're a surgeon, you operate on people, you can't be personally invested in them. You do your job as a lawyer. I mean, as a doctor, I'm a lawyer. I do legal analysis. I can't get personally invested in these. Obviously, I have an opinion about the conviction, but this is not something that keeps me awake at night, if that's what you're asking. I'm a technician. Let's see. By the way, here in Colorado, the police aren't allowed to use any kind of choke anymore. It's statutorily prohibited for police to use any kind of choke on a suspect. I'm not a police officer, so I'm allowed, living in Colorado for the brief remaining time I have here in Colorado. So let me just see. Duncan again, why do we have state prosecutors who get to decide on a whim or based on political motivations who the state should target and screw over? Is it because there was a victim who is dead and the state prosecutes on behalf of the dead? It just seems incredibly biased. We just give this power to prosecutors. They're elected. The head prosecutor is elected. The head prosecutor, the elected prosecutor was in charge of this case. D.A. Anderson, he's the elected prosecutor. We give them the authority to decide whether to charge or not. So most people don't know who their prosecutors are. They don't recognize those names when it's election day. it's a very small cohort of the population that's actually electing a prosecutor. So sometimes bad prosecutors get elected. Sometimes you have someone like George Soros who just, most prosecutor races, there's like a few $1,000s involved. There's not a lot of competition. And usually it's among, well-established lawyers in the community. You have someone like George Soros come in and drop $100,000 or $500,000 into a prosecutor's race. He's just bought that seat. And in his case, he does it for explicitly political purposes. So he's putting in that seat someone who's going to make explicitly political charging decisions, whether to charge or not charge. Let's see. We don't have a good answer for, the jury instructions have to reflect the law. The law can be technical. And the jury instructions are written by lawyers. I mean, they're prosecutors, maybe defense counsel, they're judges, they're law professors. So they're all, at least in theory, kind of intellectual. They tend to write that way and talk that way. They know they're supposed to be writing for a lay audience, but what's a lay audience in their experience, right? I mean, the social circles in which they move, most of the people they know are pretty well educated. Let's see. Duncan says, how are you supposed to render aid to someone you just stabbed in self-defense when you're still surrounded by a mob? Yeah, it's a good question. And maybe that's something the defense should have touched upon in their closing, because I don't recall them doing that. The whole wandering away and hanging out by the tubes and kind of lackadaisical withdrawal from the scene is is a bad look for Nicolae Miu, right? If he'd run away from the mob that attacked him and gone immediately to the police and said, "Oh my God, I was just attacked. Help me," that would have been a different case, right? Let's see. I have to go to the Rittenhouse verdict again to clear my palate. Yeah, or the George Zimmerman verdict. I mean, good verdicts happen. There's a lot of resources brought on the guilty side of things. Prosecutors have effectively infinite resources. The defense generally doesn't. All right. So I think Kent is asking about the Colorado. Let me see if I can pull it up. Quickly. Well, no. So what I got a proposed law for banning or constraining chokeholds from 2016. So Colorado did this over in a series of stages. First, they said, chokeholds are fine. That was the standard law, like in most states. And then they said, well, no carotid, no tracheal chokeholds, no respiratory chokeholds, unless it's a deadly force fight. Then they said, well, no tracheal chokeholds under any conditions. And then they said, no carotid chokeholds unless it's a deadly force fight. And then they said, no carotid. I think the current law is no carotid under any circumstances. You can shoot them, but you can't choke them, I believe is the current status of the law. But I don't have the statute right in front of me right now. You'd have to dig it up. But if you Google it, I'm sure eventually you'll come up with it. I've covered it before in law self-defense content. All right, so one last look at super chats. Nothing new there. One last look at the membership. Oh, No Tie Chris says he's currently a platinum member. If he wants to switch to that 82 cents a day option, should he cancel his platinum membership first? What I would tell you to do is And I'll put up that 82-cent option there. Don't just cancel anything. Email support@lawselfdefense.com and tell them that's what you want to do, and they'll just seamlessly transition you over. Does that make sense? Whichever option is the most advantageous for you is the one I want you to have. So if switching over is more advantageous to you, even if it ends up making me less money, then that's fine. That's what I want you to do. We're constantly trying to make our platinum coverage less costly, easier to access. The bigger we grow our community, the lower the cost becomes. It's an economy of scale function, basically. Although this 82 cents a day is the lowest we've ever had. lawselfdefense.com/82 cents. And unlike the straight up just platinum membership alone, it also gets you all these courses, our books, and so forth. Let's see. Where am I headed? I think I'm done with today's show. I think I'm going to take the rest of the day off. That's where I'm headed. We have the verdict. I've answered all the questions. So, folks, I think I will now wrap things up. Thank you for all your attention with me. I started covering this trial late last Thursday. I worked hard to catch up as best I could. We never did quite hear all the defense evidence, but we got what mattered, the testimony of Nicolae Miu, and now we have the verdict. Guilty of the most intentional homicide for the fatal victim and for the reckless endangerment, the lesser included charges on the other non-fatal stabbings, and the battery on Madison Cohen with a deadly weapon, even though supposedly it was just a punch. And I'll keep an eye open for sentencing. If sentencing is televised and I hear of it, I'll plan to cover that as well. But I have no doubt what the sentence is going to be. It's going to be life plus whatever, 60 years for Nicolae Miu. All right, folks, with that out of the way, I'll just remind all of you that if you carry a gun, so you're hard to kill. That's why I carry a gun. That's why I carry a knife. That's why I carry pepper spray. That's why I study jiu-jitsu. So I'm hard to kill. So my family is hard to kill. If you do any or all of that, so you're hard to kill, so your family is hard to kill, you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.